Firstly, a judgment in an interim judgment is not a final judgment. So I'm starting even before we deal with the realities. So there is nothing. Let's assume literally, which is wrong, by the way, that this was exactly about Part B, the old Part B, literal.
Challenging the rules.
Yes.
And
in other words, before, let's assume that before we appeared before, let's call it the Part 1 court, which was in June last year. Let's assume that in April, we brought another Part A application, right? And said, we know that the Saldanha court dismissed the Part A. But now, because of ABCD or whatever that has happened since then, last week we found some big letter that says this is a conspiracy or whatever. Okay? Yeah. And then we bring it. No court in this country can say no. But Mr. Prof, remember that last year or 2 years ago, when you did not have those facts, you had Part A and therefore it's a res judicata. What is that? Number one. Number two, no court in this country would say I'm bound, quote unquote, by the judgment of Saldanha J. So that's the first thing. The second one is that the nature of the relief sought in this version of Part B, and I'm working with you here, Justice Erasmus, in this version of Part B, is completely different to the nature. I'm now talking about the cause of action.
No, Mr. Paul, sorry. Mkhwebane says clearly that the cause of action, the fact that res judicata doesn't apply because of the lack of sameness of cause of action is misconceived. Mkhwebane says sameness is determined by the identity of the question previously set in motion. So it's nothing to do with the cause of action.
No. That case does not do away with the general rule. The general rule states, it comes from the common law, that the cause of action might be the same. It's a qualification of the general rule, which is correct, which simply says that the sameness must be looked at by the question. Okay, let's take
the issue. If you look at the Henderson principle, it talks about the issue, and that ties in with Mkhwebane.
Yes, but that's issue estoppel. Let's not confuse issue estoppel with res judicata.
Well, issue estoppel is a form of res judicata.
In that case, then let me argue them together. I never thought so. But if they are the same, then the issue, let's then deal with it at the level of issue estoppel, because as you correctly pointed out, Justice Gallo, if issue estoppel doesn't apply, then a fortiori res judicata won't apply. If as you say, they are the same thing.
Well, that's if you are raising issue estoppel in the form of res judicata. That's what I seem to have seen what has been raised by your opponents on the papers.
No,
I think that's what they raised.
No, they didn't do anything of that sort. What they did was to raise judicata, and then in the alternative, they say if res judicata doesn't apply, then issue estoppel. But it does, for the purposes of what I'm saying, it really doesn't matter. Let's take that at its lowest. Let's deal with it as issue estoppel. Stroke res judicata. Still, the test will not be passed by them, because the issue, this is really the point I was making, the issue that is now pending, quote unquote, in the Constitutional Court is not the same issue that was hanging before Saldanha J. Let me explain why that is so. Firstly, the one issue, which is the participation of the judge in the independent panel. Yeah. Now, the issues that are raised in this Part B application, quote unquote, are that the Constitutional Court, among other things, did not apply its own standards on separation of powers. I really don't want to go down that road, but it looks like I might have to. So that's the issue that is identified by them as if it's the same issue. No. Secondly, Justice Vele and Justice Erasmus who raised this question. The Section 172(1)(b). The reason why we pleaded Section 172(1)(b) is deliberate, because we're circumventing this kind of discussion. Section 172(1)(b) of the Constitution is for a suspension order, right? Which is a completely different legal animal to an interim interdict.
Myself in that.
So,
around 2 o'clock.
okay.
So you said
I don't know.
It was somebody on the virtual platform, an attorney, but he's muted himself now.
Yes, that much.
Just on
I'm sorry, yes.
Before you get sidetracked, can we just ask everybody on the virtual platform, just mute yourself for the whole proceedings until we call upon you. I know it's difficult, sometimes it happens by mistake, but Mr. Mpofu is now confused because of that. Right. So the section reads, when deciding a constitutional matter within its power, a court, and then B, may make an order that is just and equitable, including and the portion you're referring to is under sub 2, an order suspending the declaration of invalidity for a period and so on.
Yes, but thank you. That's what the section says, Justice Erasmus. But I'm making a small fundamental.
So they can't see anything else. Okay, so just correct.
It's just the screen because we are still here.
No, it's the laptop facing you that is frozen, so they'll be able to hear you,
so they can't see.
But they won't be able to see you.
That's correct.
So Ms. Francis will just sort it out, and but you may continue because
yes,
everybody
because
can hear you.
Can hear me. Yes, thank you so much, Justice Nathan. I'm saying I'm making a more fundamental point, and it is this. And unfortunately, again, previously it was not understood. So I'm hoping I'll try and explain the judgment of Chapter J in EFF versus Kodak, the second judgment, is exactly on this point. And that is why I always, when I want to elevate that judgment above outer, I do what I call a head count. So I say that judgment, unlike many judgments.
You may continue.
Thank you, Justice. I'll just allow.
We're just trying to get hold of the IT person, because that's her laptop.
Yeah. Okay. Thank you. My name is Junior. Just.
Let me just check with the other counsel on the platform. Can you hear us without the camera being on, Advocate Mpofu? Advocate Breitenbach?
Yes, my lord, I can hear everything clearly.
Good. Advocate Pillay? Okay.
Yes, my lord, I can hear everything clearly. Thank you.
Mr. Badlinder?
Yes, thank you, my lord.
All right, so, and there the camera, I can see them. So, Mr. Mpofu, I propose we proceed until we sort out that camera, because everybody can hear you, they can see us.
Yes, thank you very much. Thank you. But before we I continue what I was saying, just to dispose of a small issue. Page 567, Justice Gallo. You'll see that what is pleaded there, it says, Advocate Mkhwebane is pleaded by the principals of rescission to gather 4 issues from seeking what is essentially the same. So it's not, they don't argue it as the same thing as you,
But they make the point,
there's a
page 18 or 19 of the heads.
One thing of the heads, their heads.
Yeah. When they deal with issue estoppel, they say under paragraph 52, it's page 21 of the heads of argument. They make the following submission. They say issue estoppel is a modification of the classic res judicata, and then they refer to a number of cases under footnotes, under footnote 45, and then they expand on that on the next page.
Okay, that much is true. What has been said, actually, there's another case that I'll give it to you maybe in Flash, which actually even doubts whether issue estoppel is part of our law. There's no doubt in my mind, in anybody's mind, that issue estoppel is what one might call a species or a sub. It's in the same family. I forget now the genus and the species and all that. But it's not the same thing. That's the point I was making. That's all I was saying. It's the big mother of that family is res judicata, and then it might have a whole lot of children. So I just wanted to clear that up. Anyway, I was not there. The point I was making, Justice Rasmus, is this. And I was when we got cut off, I was making this point that how I normally elevate EFF versus Federal, depending on which side of the argument. And that we do by the following. That judgment, I always say, is the only judgment, well, not the only one, but it's a judgment which has been actually made by 22 judges. And everyone said, how do we come to 22? It is because the judgment of Hampepe J, which is the main judgment, was unanimous for the whole court. But so was Chapter J's concurrent judgment. It's also consented for by the full court. So the two judgments put together each have, unlike outer, by the way, outer, as I pointed out in our heads, has a very strong dissent, which I'm sympathetic to, by Froneman J. But here we have a unanimous ×2 judgment. The only contribution that Justice Jafta wanted to make, Justice Erasmus, was to give an answer to what you're saying, that the relief sought in a suspension order is not the same thing as the relief sought in interim interdict. Hence, he said, outer doesn't apply, which the answer I gave to Justice Gallo in a different context. Now, what has that got to do with this so-called issue estoppel, or whatever you call it, issue? It is that it's two things. The relief sought in prayer 2 has got nothing to do with is a suspension order, and that is why it says there, in terms of Rule 45A, alternatively in terms of Section 172(1)B. That's what it says in the notice of motion. That means that that relief belongs to the category that chapter J was talking about, at 113 of EFF as per that, says, however, the High Court did not limit the remedy it granted towards an interim interdict, unlike the Saldanha J Court, right? It went further and suspended the operation of the remedial action pending the final determination of Part B, right? And then it gives the order. I'm reading from 112, if you're there, Justice. Then 113, which is where the crux is. Therefore, even if it could be said that there were prospects against the grant of the interdict, the applicant for leave would still be faced with the question whether there were prospects against the suspension. Requirements for suspension differ from those needed for an interim interdict. Can be clear about that. In other words, this is a completely different issue, cause of action, whatever you call it, whether you do it as issue estoppel or as proper res judicata. It's not the same thing that was faced by what's by the Saldanha J Court, or at least not the same thing that it's decided, right? So that's the second answer. The third answer. But
you also dealt with the 172 argument.
No.
It was raised for the first time in argument before that court, and he dealt with it in the judgment.
Not
the 172 point.
Well, he might have dealt with it in the judgment. I'm talking about I'll check that. I'm talking about the order. The order that was granted is the same as the one that is referred to in 112 that I've just referred you to. If he dealt with it, that would be a miracle. But miracles.
Well, you were in the case. I read it in the judgment, and I can find it for you.
On the basis that miracles do happen, maybe it will be there. But the point I'm simply making for now, Justice Erasmus, is that certainly the relief that was granted on the basis of interim interdicts and outer and all those things, not on the basis that outer does not apply. Actually, that's what he dealt with, whether outer applies or not.
Well, he deals with outer, and then he says in paragraph 24 of the judgment, that to be found at page 593 of the consolidated bundle of authorities presented to us.
593.
In respect of the relief sought under section 1721B and raised for the first time in argument, I'm quoting from the judgment of Saldanha J. In argument in the reply by counsel for the applicant, that was you, he submitted and so forth and so forth, and then he says, I will revert to this contention, and later on in the judgment he then deals with the issue. So it's not that 172 was not before the Saldanha court. That's the only point I'm making.
All right. The order, the relief made by Saldanha J, and this, there can be no miracle about this one. The order was made on the basis of the application of outer, right? That is beyond debate.
And he said outer applies.
Yes, and he said outer applies. That's the giveaway. The point I'm making is that if outer applies, outer only applies to interdicts, right? As chapter J just explained now. That in the same paragraph I was reading now, the part I didn't read, I thought it was irrelevant, but now it has become relevant. The last sentence of paragraph 113 of chapter J's judgment is that outer does not apply to the suspension. So insofar as there's also some weird suggestion that you are also bound, in other words, in the sense of res judicata, stare decisis, which is West. So now we have three animals here. We have stare decisis, we have res judicata, and we have issue estoppel. Insofar as that is suggested that you are bound by that judgment purely on the basis of stare decisis, that is just fallacious again, because the ratio of that decision was the fact that outer applies.
I see to you, I'll find it for you. It's on page 610 of the bundle.
610.
It's paragraphs 128 to 131 of the judgment
So it's 610,
by the full court. Yeah, it's 610 of the consolidated bundle of authority. And then he comes to the conclusion at the end of the day. He says, I'm satisfied that it is just and equitable that the process of the removal of the applicant in terms of the new rules not be suspended, and that the applicant is likewise not made up a case for relief in terms of section 1721B of the Constitution.
Exactly.
And he deals with, when he summarizes your argument, he uses the words that you've used in argument here, the nuanced approach of Jafta J in the second majority judgment. So,
yes. No, Justice Rasmus, please.
you don't have to beg me.
No, I think I have to. Taking us back down to the first point. The first point which I made, which I was making when I was told that let's do it as issue estoppel, which I have agreed to. Let's do it as issue estoppel. One can never say merely because there was an application to suspend something called X, okay, which was the even before the so-called independent panel even existed. Okay, this was like early days. Actually, I don't even think I think the only thing that had happened then was submission of the motion. Okay, then you say, remember, let's look for the word suspension. Even now, though now you are suspending something called Y, which is the committee, let alone the independent panel. You've even gone many steps ahead. And then you say, no, but let's just search for the word suspension. Because here you are asking for a suspension, and here you are also asking for a suspension. Therefore, it's a res judicata or unbound. If that is the law, then I don't.
No, all I'm pointing out is the argument is made that the application before the Saldanha Court, this full court led by Saldanha, was an application to interdict the Section 194 committee and whatever else goes with it from proceeding under the new rules that included the judge panel, if I can say that, and in the non-legal representation. I'm just taking those two. The full court then, the Baartman full court, found those two are unconstitutional. They understand unconstitutional broad sense of the word. You then went to the Constitutional Court, so it's then a continuation of Part B, because that was Part B, that was heard by the Baartman Court. And the Constitutional Court said, no, the judge panel, that's okay, there's no problem there. Legal representation, issue new rules. Then you applied for a rescission of that on various grounds on the judge panel issue. That's how I understand it. Yes. And then, of course, then 6 May happened, and now the application. But there are new facts that might have arisen that will impact on your application, the new application, the 10/11 May application.
Right.
So that's the logic that they take it through on the line, and they say, so all of these issues were raised. You asked for an interdict before the Saldanha panel to stop the process that's going on. That's been dealt with. And there's nothing new in that. Same facts, same parties, and so forth. And they mentioned the 4 principles and then referred to Alta and so forth.
Yeah. Okay. I didn't want to interrupt your Lordship, but the starting point of that summary is wrong, because you said, my Lord, that before the Saldanha Court wanted to interdict the committee. No, it's a crucial point that I'm trying to make. We did not want to interdict any committee. There was no committee in existence. It was long, long, long before such a thing was born. The Saldanha Court, and this is the crux of what I'm trying to articulate here. Saldanha Court was, that's what when I was making these examples, was interdicting something completely different, right? Whether you look at it as a cause of action or as an issue or whatever, but it was a different animal.
It was called in the notice of motion, the section 194 process.
Yes, but we just agreed that if new facts emerge, I'm trying to explain to the court what new facts have emerged. I'm saying those new facts are that there is now something called a section 194 committee, which was not in existence at the time. Now, I'm therefore saying that according to Mr. Reitenbach, and we all embrace that, there is what is called a 17-step process. And that's important again because this confusion is made sometimes deliberately between process and proceedings, and I'll deal with that in another context. But let's take Mr. Breitenbach's 17-step process. All I'm saying, Justice Erasmus, is that when we were before the Saldanha J court, and I can't remember now. Let's say we were at stage 5. I'm just making it up. Right? I mean, step number 5 or 7. Now we've moved the new facts before you, and that we've moved from 7 or whatever it is to 14. Let's say. Again, I'm not married to making up the numbers to make the point. So that movement from stage 7 to 14 presents exactly what I am articulating as the new reality. It's the same as that ridiculous example I made of finding some smoking gun or something. Okay. So this is at a legal conceptual level. That is the relief sought or rather. The relief granted at a particular point of point 7 cannot be equated at any level, whether it's as an issue or as a cause of action, to the relief now sought. And that really comes from a very simple principle of law. That is exactly why you are allowed to bring interim interdicts ad nauseam, if you like, to go back to that example of where you draw the line. You don't. If I bring an interim interdict down and then some new facts arise, I can bring it again and fail. And another set of facts arises the following month, I can bring it again. There's no line. So it doesn't help to postulate all these ridiculous things, because imagine if I came to this court and said, at now stage 9, the new facts that have arisen, I want another interim order. Then the court say, well, what will stop you from coming again at stage 10? Nothing. That's the answer. So it's very easy to exaggerate the problems that have not existed or that are not that are postulated by so-called experts who are writing in newspapers. But the reality facing us is that relief is qualitatively different. And I'd like to move away from it because I have no doubt that the so-called...
The first and second respondents are going to argue that point.
Yes,
strongly. And of course, if we're with them on that point, then it's the end of the matter. So I wanted to give you enough time to deal with it and deal with it up front before you get fuzzied by all the other issues later in the day.
Yeah. Well, firstly, okay, that forces me to deal with it now.
Yeah.
Because it cannot be the end of the matter. It cannot be, because the application has now been brought on 3 alternatives. One is the normal interim interdict, Sipokelo, outer, whatever you like. 2 is Rule 45A, and 3 is 172B. If anybody is going to tell us that that is the same thing as what was argued before Saldanha J, well then that's the end of the road.
Mr. Mpofu, this is where I have some difficulty in understanding your argument. Let's, for the purpose of my debate with you, let's forget about the words relief, and let's forget about the words cause of action. Let's think for a moment about the words issue. What was the issue that was determined in front of the full court headed by Judge Shivambu, and the issue that was determined by the full court headed by Judge Barton? What is the difference between those issues and the issue that is before us?
Okay.
Let's forget about remedy, cause of action, relief. Let's talk about issue.
Okay. That's even easier than the issue before Saldanha J is the one I explained by using my cell phone. I said the issue there was whether at stage 7, which I'm making up, the process should stop. Let's just say, for example, the qualification. And Saldanha J might have found that it's too early in the process or whatever for me to stop it, or I'm exercising my discretion, whatever. Right? The issue before Batman J's court was a completely different matter. It was whether the rules are unconstitutional. Okay? Not whether, because the rules might be unconstitutional one day, we should stop the process now. 2 different issues. Let's at least agree on that. Then the issue which is now before the Constitutional Court is whether the Constitutional Court committed a rescindable error in determining the one constitutional issue. By the way, Justice Erasmus, before I forget this point, so those are the 3 different issues, but I'll still come back, Justice Phil. By the way, the argument that one of the arguments of the variations of this argument is that you are bound by Saldanha J's determination on the interim relief. How on earth can that be when that judgment was clearly wrong? Right? How? In which world does a judgment which has been overruled, for lack of a better word, and discredited, become binding to this court. How can the same judge, Saldanha, who said that there is no need for the public protector to have legal representation as part of the basis for his refusal of the Part A, which idea was poo-pooed by the full Batman Court and the Constitutional Court. And but honestly, and for anybody really to come here and say that that judgment, based on an idea that was rejected by the highest court in this land, is binding on you, it's just, I've never heard of such a thing in my entire life. The Saldanha judgment has been twice reversed on a crucial aspect, which brings us here. Had it not been, actually, you wouldn't be sitting there and I wouldn't be standing here. Had the Batman J Court and the Constitutional Court agreed with that wrong judgment, then we wouldn't be here. But somehow it's now has some binding effect on this. Please, not on this court. Anyway, I think that's enough said on that. It's just a red herring, please believe me. This so-called issue estoppel or res judicata is nothing but trying to pull the wool over the eyes of the court. So can I deal with the merits?
Yeah.
Okay. I said there are 5 judgments. The first judgment, which I would like you to pencil in, is I can't believe that we all did not put this judgment in until yesterday. You would have received the judgment yesterday, the EFF impeachment case. I don't know if
that's why that's also referred to in the Saldanha judgment.
It is, yes. That's why I'm saying I realized it as I was getting into the aeroplane that for some reason this judgment is not here. It's referred to everywhere, even in the clarified judgment of the Constitutional Court. So it was just a faux pas. Now, that judgment, there's no way that this matter could be decided without referring to that judgment. Really. Because, why? That judgment is the sans et erigo of these rules that we're talking about here. I know that because I was in that case. We argued there that you cannot impeach a president without rules. And as a result, we successfully argued that the judgment of Chapter J. And as a result of that, Parliament then developed. Then, do you still have everyone?
Yeah.
Okay. The Parliament then, my lord, developed the Rule 89 rules. You'll remember. Those rules were literally modeled. Whoever drafted those rules must have had that judgment and then drafted the rules. Okay. Now we know, as a matter of fact, that these rules, the ones before you, were in turn modeled literally on the Rule 89 rules. Literally, I think it's 95%. I counted it at some stage. There are only 2 or 3 modifications where it says president, just says public protector or whatever, or Chapter 9 institution. But those rules are a carbon copy of those rules, of the Rule 89 rules. So it is impossible to assess a matter, this kind of matter, without looking at particularly the majority judgment of chapter. And that goes, by the way, to one of the issues I'm going to talk about the illegality, sheer illegality of the so-called committee usurping the powers of the Speaker and the National Assembly. That judgment makes it clear that the authority for these rules is the Speaker, or rather the National Assembly, obviously by the office of the Speaker. But that's an aside. The second judgment is, well, let me deal with their implications because others are not so important. This one is very important. One of the issues that is said in the judgment of Chapter J in the EFF judgment, you will find that I'll find the paragraph now. But this is a very crucial point which must not be lost here. He says that, and that goes to the rights now of the public protector that we're trying to protect. He says the reason why there must be rules for an impeachment process as opposed to a motion of no confidence, which we dealt with in another case, UDM, which one of the big five. Again, there we successfully established the related principle. He says, Justice Chapter, the key distinguisher between this is because an impeachment process is punitive. I'm sorry, it's fine on my file. I'm sorry. Yes, it's paragraph 138 of that judgment. In contrast, the removal of the president by means of impeachment is subject to certain conditions. It must have as its foundation at least one of the grounds listed, section 891, and the impeachment itself must be supported by a 2/3 majority. The reason for this distinction in process is that impeachment is punitive. Let's just pause there. We know. Remember, one of the issues we're going to be dealing with here is going to be an interpretation exercise of section 194(3)(a). Everybody knows, sure, that the interpretation of a penal or punitive section must be done in a particular fashion. In fact, firstly, it must be done in favorem libertatis, in favor of the individual. But it must also be done in terms of section 39(2) of the Constitution and so on and so on. Okay. Now, hear this. Here, remember, Justice Jafta was dealing with the section as a whole, section 89, which for present purposes is the same as section 194, right? As a penal provision. Here's the thing. Here you have a double penal provision. Now, something worse than what Justice Chapter was dealing with. Because within the penal provision, which is 194, we're now dealing with the 194(3)(a), which is a suspension provision. Suspension is, by its definition, by its own nature, punitive.
Why do you say this?
Because
Suspension of whom? Because remember, before us as the applicant is the Office of the Public Protector. It's not the actual incumbent of the Public Protector. That's the party before us.
Yeah.
So if you suspend, you have a precautionary suspension of the incumbent to the applicant. How is that punitive vis-a-vis the applicant that's before court?
Yeah.
The office continues.
No. They can't suspend an office. You see,
I'm not just saying you can suspend an office.
Yeah.
I'm saying the incumbent is the person that may or may not be suspended. But how can you say that is a punitive measure? The incumbent will get full pay during that process.
Yes, okay. Finish. All right. It is because, firstly, and I'm not saying this facetiously, you cannot suspend an office. You suspend a person, human being. All right? So, just as you cannot remove, it's the same thing that Chapter J was really trying to explain simplistically. That answer could be, how you're suspending the office of the president and not the president? No. You suspend as if you go to paragraph 139 of the same judgment. It's the same paragraph. Depending on the ground which is faced, the impeached president may lose all benefits and be barred from occupying any public office. So that's for the president. So let's call it punitive quality number 1, to distinguish it from the one that we are reading. So the punitive quality number 1 is that impeachment, which is, if it was a normal employee, it would be dismissal, is by its nature punitive for the reason that Chapter J was explaining. Okay, so that's the impeachment itself. But what I'm saying, I don't think that's arguable, really, that an impeachment is punitive. At least that's what the Constitutional Court says, so I'll stick by that. But the point I was making is a further point, which is the one you're asking me, Justice Hill. Namely, that within that punitive regime, which the Constitutional Court says we are now dealing with another punitive issue, which is called suspension. And you say, why? Because there is suspending the office.
No, I'm not saying that.
Oh, okay.
You misunderstood completely my question.
Yes.
I said a precautionary suspension of the incumbent to the Office of the Public Protector. Mm-hmm. How is that punitive? Okay. The precautionary suspension of the public protector. No, the incumbent to the office of the public protector. Yes,
but that's the same thing. Okay, let me make it easy. The suspension of Advocate Mkhwebane, right?
Precautionary suspension.
Suspension.
With pay.
Yes, with pay, everything. It's by definition, the suspension of anybody, including Advocate Mkhwebane, or a judge, or a president, or whatever, is ipso facto punitive, because and that is why Section 177(3). Section 177(3) of the Constitution
Yes, I'm with you.
Thank you, Justice Bello. Okay, let's start at the beginning.
Section
177(3) of the Constitution, which is the analogous section about the suspension of a judge. So the President on the advice of the JSC, may suspend a judge who is the subject of a procedure in terms of subsection 1. Now, the reason why that happens at a particular stage, the suspension of a judge who is being impeached, Justice Gallo, is because it is a draconian and a very punitive. Well, I'm sure anyone who was, if the judge, who was the judge that is being suspended, would know that that is nothing short of what in Mkhwebane was called. If you go to page 243 of the joint of the authorities manual. His Lordship Justice Andika answered that question beautifully. It's one of my favorite expressions.
Isn't it one of the top 5?
Yes. No. This case is not.
Okay.
No, but it has just been elevated just for the purposes of this argument. No, it's a second-rate case. But I'm saying, second to what my favorite expression in law is the one that says it is better to release 9 guilty men than to convict 1 innocent one. But my second one is this one. It says that insofar as the substantive dimension of fair dealing in relation to suspension is concerned, I'm reading it paragraph 81. Halton Children has observed that suspension is the employment equivalent of arrest, with the consequence that an employee suffers palpable prejudice to reputation, advancement, and fulfillment. Right? So that is.
Give me a moment, please.
I'm sorry.
Thank you.
Yes.
Yes. Even the respondents, as they are, and where they insult Mkhwebane at the slightest provocation, particularly the first one, do not and cannot argue that her suspension, simply because she is getting paid, is so
It's not punitive.
It's not punitive, yes, or at least seriously injurious to her rights. And that is because Justice Gallo, by definition, and as I say, well, as someone who was once suspended, if maybe it's easy to theorize about this, but to be suspended from work, any work, is ipso facto, as Halton Chidle says, injurious, A, to your reputation, 2, to your dignity, right? And 3, to your self-worth as a human being. Now, only people who, where is the case, there are 2 cases which we cited in our heads.
The other one was
By
Sachs, J.
Nugent, and then Sachs, yes. Yes. We start by, it's paragraph 80. Thanks so much, Justice Shivambu.
Mr. Mkhwebane, once you finish
This one.
the section, we're just going to take a short adjournment just to stretch and
Yes, thank you very much. Thank you very much. Yes, I'll run
that's
quickly.
about 2 hours in.
Yes.
Since we started, we'll take a short adjournment.
Yes. Fair enough. Thank you, Justice. Right. We say paragraph 80, Justice Miller, of our heads at page 30 thereof. It is indisputable that, well, we thought so, as a general rule and by definition, any suspension from work limits the suspendee's rights to dignity, reputation, and work. It has been correctly observed that suspension is the employment equivalent of arrest, with the consequences that an employee suffers palpable prejudice to reputation, advancement, and fulfillment, which is what I've just heard from Mkhwebane. In the same vein, the SCA, by Nugent JA, made it clear that suspension with pay, which is your question really, suspension with pay does not diminish the adverse impact of the rights of the suspended person because, quote, said Nugent JA, the freedom to engage in productive work, even where that is not required to survive, is indeed an important component of human dignity. That aspect, which we were told in S versus Mapanyane, is the fundamental pillar of our constitutional dispensation, dignity. 4, said Judge Nugent, mankind is preeminently a social species with an instinct for meaningful association. Self-esteem and the sense of self-worth, the fulfillment of what it is to be human, is most often bound up with being accepted as socially useful. That should be self-evident. But the Constitutional Court, because we've now taken it to all 3 stages, the Mkhwebane is the lower court, the SCA, what does the apex court say? Justice Sachs said in Maseta, fairness to an incumbent, which is the word you use, Justice Miller, incumbent. Fairness to an incumbent, right? Not to an office, to an incumbent, about to be relieved of a high-profile position in public life, presupposes the display of appropriate concern for the reputational consequences. People live not by bread alone. Indeed, in the case of career functionaries, reputation and bread are inseparable. I don't think that needs any further explanation. But to round off the point before we take a short break, the point I was simply making really is that assuming that it is not contestable that an impeachment provision such as Section 89, 177, or 194 is ipso facto punitive, which is what, well, it can be debatable because that's what the Constitutional Court said. Assuming that is not debatable, and assuming the second proposition I was making, which is that this is a double whammy, if you like, or a double punitive provision, because 194.3a, which lives in a punitive section, is in itself punitive because it's a suspension provision. So you, my lords, will have to exercise double the required effort in interpreting Section 194.3a in particular, because it is a double punitive statute. I think that that rounds off that point. So the short
would 15 minutes be the best time? I know it's difficult for counsel to leave the court building. So I want to keep it as short as
15
possible.
would be enough.
So 15 minutes. So from 5 to 11, we will return at 10 past 11.
That's quite busy.
11:10. Mr. Mpofu, just before you proceed,
Yes, fine.
I've been alerted, I don't know if it was somebody who sent me a message to say that the microphones were left on when the court adjourned. And so everybody that was still on the platform could hear what people were saying. So,
yes, someone said that. Well,
to the IT, maybe just
must be the IT people.
during the adjournments to mute.
No, we thought it was
and
the,
autistic people can be.
when they adjourned. Yes. No, we thought it was the TV people who explained to them it was a consultation. They were not allowed to.
Yeah.
But anyway,
Yes, and then I apologize that we were 5 minutes late. One of my colleagues had the wrong impression that I said from quarter past.
Thank you. No, that's fine. But before I continue, I just want to tie up a few loose ends. As your Lordship knows, during the break, we pick out a few things. I'm not going to ask you this, just trying to alert you to the question. The first one, and both of these come from this, well, at least the first one comes from what I call these pseudo professors and other so-called experts. The thing we debated this morning about can you rescind a decision. I want to refer the court to page 260. Remember, firstly, 260 of the main bundle.
Of the main bundle?
260, yes. That's the document, the bleedings bundle. Yes. Remember, the background to this is the point I made earlier, namely that an order, any order of a court of law is rescindable. Any order. Doesn't matter.
260.
Doesn't matter that it might be.
260 of the main bundle, I see it's part of the letter.
Yes, yes. I'm just giving you background. The background to this is the submission I had made that there's no limitation to what orders can be rescinded. At least that I know of. Not in the common law, not in section 42 of
Rule 42.
Rule 42, thank you, and not in terms of section 172. Certainly not in terms of section 172. And even 45A. All those four standards don't say they are orders. But here, just because it is the so-called Stalingrad police, they say that this rescission application was something that was like an afterthought and something that was, meant as a delay intent. I'll look at paragraph 8. This is a letter that Mr. Sianeho, my attorney, wrote as far back as 23rd March 2022. And it related to this issue of the so-called letter of request, even before the alleged judicial capture allegations. At paragraph 8, it says, to entertain or even act in accordance with such a quote letter of request would be patently unconventional, if not downright irregular, and would certainly constitute a new rescindable error. In addition, the grounds raised in the relevant applications. Rules cannot be made in an impromptu fashion for specific litigants as we move along. So even then, before Mr. Abraham G came into the picture, we foreshadowed that should the so-called urgent entertainment of the rescission, which has now happened, as Mr. Abraham G predicted, that if that happens, then that would be a rescindable error in its own right. That's what we said then. And the reason why we are confident now to say that Mr. Abraham G is either a sangoma or there's something more serious to it is because As it happens, your lordships will know, Mr. Justice Erasmus referred to it earlier, about the rescission of the judgment. That rescission, as your lordships know, was submitted, I think, on the 23rd of July 2021. I might be wrong about the date, but it was certainly July 2021. And the ruling came about 8 months later, in February, March, actually, in early March. So compared to that, this one took 6 weeks or something like that. So it's clear that it was a response to that letter of the agency. The agency that pleaded in a letter, never heard, but be that as it may.
How can you say it's the response to the letter? It's clear that it's a response. The letter is written by the state attorney on behalf of the speaker,
Yes.
and it's sent simultaneously with the notice to oppose the rescission application.
Correct.
And I've looked at the email addresses. So it's the chief registrar, the admin in the general office, the director of the Concord. Those are admin people, the Visagie at Concord.
Yeah.
And then they request that certain information be brought to the attention of the acting chief justice. Now, the acting chief justice was not part of the panel that decided the matter. And therein is an indication of the timelines that Parliament has, the one I talked about. And the request is the following. We are further instructed by the Speaker to respectfully request that if the acting Chief Justice decides to issue directions, that's the Rule 18 directions, for the filing of papers by the parties, then, if at all possible, in the light of the public interest in the finalization, one way or the other, of the process for the impeachment of the public protector, such that directions be aimed at enabling the court to reach a decision, on the rescission application before 4 May 2022. Now, this happens every day. That parties, attorneys would write to the leader of the court, the judge president, for example, requesting early allocations or indicate why a matter should preferably be placed before a full court, etc. You will know from your experience. I will know from my experience, and also I headed the court at some stage. How can you say that they've expedited simply because of this letter?
Okay. Thank you. Let me assist you, Justice Erasmus. Firstly, it does not happen every day, not in the Constitutional Court, because there is no equivalent mechanism. I'm sure I was lucky the first time. I'm sure no one is going to any one of Erasmus. But there is no equivalent mechanism like the practice directions that were given by the president of the SCA on the 14th of July 2014, which say that if there's an appeal and you want it to be expedited, this is what you must do, blah, blah, blah. It's set out. There was a reason why it was set out in the because it was saying all sorts of people are writing to the registrar and so on, which is what you say happens every day. It was to stop exactly that. And that's why the direction was given. In the Constitutional Court, there is no similar mechanism. That's number one. Number two, what happens every day, actually, in all courts around the whole country, is that if you have a reason for urgency, you must put it in an affidavit. Why is that so? Because that does away with the abuse, which is what this is, of writing a letter that nobody, there's no comeback. You just write a letter. The reason why urgency is added in affidavit is because the other person who might not feel that it's urgent will then put their own affidavit on the oath and say why it is not urgent. That's what happens every day, right? Now, so that's number 2. Number 3, I've just given you a comparison, Justice Erasmus, about a rescission application between the same parties, which took 7 or 8 months to decide. And you expect the public protector to believe that this one that took 6 weeks, after her experience of an 8-month wait, the one that takes 6 weeks was not because of the so-called request? No, I'm sorry.
It goes further, Mr. Mkhwebane. When it was sent, and I don't know whether it was transmitted electronically to the other parties as well, because the whole list of the participants in the previous
it certainly came to us. Yes.
It was sent, and then your attorney then immediately, 5 days later, on the 23rd, he submitted his response to the registrar, the same.
The one I was reading to you now.
Yeah, and he just copied in a further person, Mativa at Concord, and the decision was only given on the 6th. No, I know what you're going to say about that, but I'm saying that was the 6th of May.
Yes.
So this was in March, and in the decision given, the panel, not the Chief Justice, the panel says there was no need for directions to be issued, and therefore dismissing on the basis.
Right. Okay.
Just to complete the timeline.
No, thank you. Thank you. I'm indebted to your lordship. Enter Mr. Abraham G. This is exactly the biggest scandal ever to hit our courts, because Mr. Abraham G says to Mr. Breitenbach on the 24th, don't worry, Mr. Breitenbach, let the Mbofus and the Masukus of this world be busy preparing. You can go and fishing, because the Constitutional Court is going to give the judgment you want on next Friday, right? Which is the 29th. Now that, if anyone wants us to believe that, let's just say for a minute that the judgment came on the 29th, but comes to the fish of the 6th. That was not in compliance with this letter that says this must be done before the 4th, because all sorts of things, including lies, which we pointed out, have been said, not under oath, as in the usual. Then, I mean, I don't think anybody can argue that. That's the first thing. The second thing is that the mere fact that the judgment is delayed by a week, I mean, we're not children. The mere fact that it's delayed by a week cannot, by any stretch of the imagination, be read to mean that what Abraham G was saying was not going to happen on the 29th if it had not been outed. So let's just stop there. So really, to believe that a judgment which, and you will work with me here, Justice Erasmus, which would have been given, all things being equal, on a Friday before the 4th happened, was completely just fortuitous, unrelated to the request for that judgment to be given before the 4th of May. is beyond my comprehension.
But that would require that the Constitutional Court, for that theory, the Constitutional Court must have withheld something.
No.
Remember, Abraham G says 29.
Yes.
You don't get the judgment on the 29. What had happened? One, either the judgment was not ready and was not going to be given on that day. The alternative is somebody said, oh, we must cover up.
No.
What had happened?
Yes, no, I agree those are alternatives, but those are not the only alternatives.
What's the other alternative?
The other alternative is that, as we know now, actually it's not even an alternative, it's a reality. On the 28th of April, yes, the day before the Abraham G prediction, the Chief Justice gave an interview on SABC, right? He said, he was asked 3 times, has the decision been made? He gave 3 different answers. The first one was,
You filed the transcript of the
it's volume 2, page 152 of the new, of the supplementary index, what we would call the supplementary index.
page.
152, my lord.
Yes.
First time the question is asked. Before I get into that question, I prefer asking this way: is there a decision around the issue of the public protector that is pending, imminent, not eminent, imminent? Then the Chief Justice says, well, the matter is pending before the Constitutional Court. The Constitutional Court will announce this decision when it is ready. Let's just pause there. It's not saying a decision is not made. It's saying it will announce it when it is ready. That's a completely different thing to what is being asked, but let's just pause that for now. Then the reporter tries again. Has a decision been taken? Then, Chief Justice, the Constitutional Court will announce when a decision has been taken.
The first question was whether it's imminent.
Yes.
No.
Yeah, but the same answer was.
Then it says it will announce when it's ready.
When it's ready, yeah. Which, as I've said, in anybody's language, it doesn't mean that it's not. It will announce when it's ready. It doesn't mean.
It was also stated in an affidavit.
Yes.
In these further affidavits, and it's set out, and then it says, unfortunately, the Chief Justice 3 times gave different answers, and
I'm going through that.
By implication saying he lied.
No.
How else must I read it?
No, well, I don't know, Justice Erasmus. I'll tell you how the public
That's what the
protector
department says.
Yeah. Well, I'll tell you how the public protector read it. Okay, the public protector explained exactly how she read it. Firstly, let me just finish the sequence. So again, the interviewer tries for the 3rd time. So the decision has not been taken, and then Chief Justice, the Constitutional Court has not yet announced a decision, and therefore there is no decision that has been taken, whatever.
So the first question was whether it's imminent, and then he doesn't say whether it's been taken or not. He says they will announce it when it is ready.
Yes, doesn't answer the
Then
question.
he follows up. Has it been taken? It's a different question to the first one.
Well, The answer is the answer that
That's
I'm
a
worried
different
about.
question to the first one.
No. It says, is there a decision? It's the same question. Is there a decision or is there not? All right? Before I get to the question, I prefer asking this way. Is there a decision? Okay? Around the issue that is pending and imminent.
No. Why do you place the emphasis on is there a decision?
All right.
The question reads, where he asks the question. He first gives an explanation, background to the question, then he says, before I get into that question, I prefer asking this way, is there a decision around the issue of Public Protector Mkhwebane that is pending, imminent?
Yes.
And then the Chief Justice answers, says, well, the matter is pending before the Constitutional Court. The Constitutional Court will announce its decision when it is ready.
Yes.
Then he says, he now asks, has it been taken? Then the Chief Justice answers, he says, the Constitutional Court will announce when a decision has been taken. Then he follows up, he says, so the decision has not been taken. And then he ends the sentence by saying, therefore, there is no decision that has been taken.
Yes. Okay. No, well, I don't
So
know where there's no misunderstanding.
Where's the three different stories?
Yes. The first one. Okay.
That the deponent says.
Actually, now on this analysis, there's a fourth one coming. The first one is there a decision that is imminent, sorry, as you correctly point out. Is there a decision that is imminent? The answer doesn't answer the question. It says, well, the matter is pending before the Constitutional Court. The Constitutional Court will announce its decision when it is ready. So the question, is there a decision that is imminent or not, has not been answered. Let's at least agree on that. Then he says, and I'll take your slant on it. Has a decision been taken? Let's assume that is a different question for now. Then he says, the Constitutional Court will announce when a decision has been taken. Again, the question is straightforward. Has a decision been taken? Yes, no. And then that's why he asked for the third time. So the decision has not been taken. And then he says the Constitutional Court has not yet announced a decision. Therefore, there's no decision that has been taken. So at that point, we now have the version that no decision has been taken. Okay. Now go to the what I call the fourth version. But what do you make of that which I've just said in terms of someone texting and saying that I have it on good authority that the court will decline the rescission application? You may not have been privy to this, but it's out there in public and people are speaking about it. And let me pause there. This is the harmful or the painful part about this. This court, when it adjourned or postponed the matter on the 26th, correctly, with respect, correctly said, or at least agreed with the parties that two things should happen. Clarity must be given on what happened. This is not clarity. Secondly, the dignity of the judiciary, I'm paraphrasing, in that process must be protected. And that's what this journalist is saying. So this thing is out there and people are talking about it. This is the response. So let's assume he's now prodding for the fourth time. So here's the response. Well, of course, one can't control what one person communicates to somebody else. This came to my attention and I've decided that it should be investigated. It is being investigated, and once there is finality, we let the public know, but certainly it's something that's very concerning. And well, I said to you earlier, on the Constitutional Court hasn't taken a decision. I must say to you, I said to you earlier, most of the time I was in meetings. If it has taken a decision, so for the first time now, the possibility of a decision being taken is introduced.
No, read further.
Yeah, that's exactly what you mean. If it has taken, I was just pausing to emphasize that part. If it has taken a decision in my absence, the Chief Justice is laughing, then it says that might have, but certainly, as far as I'm aware, it hasn't taken a decision. If it has, again, introducing the possibility that it might be taken. Any decision, it would have been within the time that I have been in meetings. So I just thought I must explain that, but certainly it's completely unacceptable what you do, which we all know it's unacceptable. But the point I'm simply making is made in the public protector's affidavit. This is PCA 2. You'll find out, my lord, at
It will be on that.
Where it refers to
on
that,
volume 1 of 4.
volume 1, 2 of 4. Where we refer to this letter. This was 20. I'm sorry, my lord.
I think it was in 1 of 4.
In the factual analysis of what has happened since the it's in the Rule 65E application that I'll find it just now.
It will be.
Yes.
It will be here where I found the.
In the supplementary minutes.
Yeah. That's the one where
it's the recent one that came on Sunday, my lord.
yeah, that's it's in volume 2 of 4.
I'm told it's 152.
No, 152 is the transcript.
152 is the transcript. Yes, I was looking to where it is referred to in the affidavit. Thank you. Okay, sorry. Yes, no, it's in earlier, page 14. Page 14. 104. Yes.
Yeah.
Yes. This is what is said, my lord. I mean, if this doesn't make sense, then I don't know. So, a crucial development, sorry, I'm starting at page 13. A crucial development which is somehow left out of the RPN, that is the respondents left this out for some reason, is that on 28 April, and shortly prior to the above mentioned letter from the Constitutional Court, the Chief Justice gave an interview on SABC television, she says. In the interview, and regarding the issue of the decision referred to in Mr. Abraham's SMS, the Honorable Chief Justice, with respect, did not give a clear and unambiguous answer, and that I've just explained that. Importantly, the Chief Justice acknowledged that, quote, "It is completely unacceptable for anybody to say that anybody that the court has made any decision that the court has not announced." Let's just pause there. Look at that statement. It is completely unacceptable for anybody to say to anybody the court has made any decision that the court has not announced. Those are words, actually that's the fifth of these versions. So you could have said, to say anybody, the court has made a decision that the court has not made. And it says that the court has not announced. Okay? I say these utterances tend to indicate inter alia, which I've explained earlier, that some decision may well have indeed already been made, but not yet announced. That is self-evident. The second, then you say, when the interviewer repeated the question with a view to seek clarity on this issue, the Chief Justice then seemingly categorically stated that no decision has been made. So that's the second thing. However, later during the same interview, the Chief Justice sought to explain the issue by giving a third version and stating that the Constitutional Court may have made a decision referred to by Mr. Abraham G. in his absence, that is the Chief Justice, during the time that he had been busy in meetings. This is now the part that really comes to, owing to the resultant confusion on my part about what the actual position was. In other words, it's the public protector here speaking, saying, I'm faced with this, and I'm faced with these 3 or 4 versions that come from this. And then owing to the resultant confusion on my part about what the actual position was, I instructed my attorneys to seek clarity. No one can fault her for doing that. If deemed necessary, a video clip of the interview will be played for the court. For ease of reference, I've taken the liberty to request parties to prepare a transcript of the interview. Here's the thing. It says that I later addressed on 3 May a letter to the Chief Justice. In other words, simply to seek clarity, because this is as clear as mud. So to seek clarity, she wrote a letter dated PC-N, PC-7. To save time, I will not go to that. But that letter simply said the same thing that the journalist was grappling with. Has a decision been made, or has it simply not been announced, and so on and so on. I've gone through all
Isn't it because it was a press conference or an interview and not in an affidavit?
Fair enough.
And not under cross-examination?
Yes. No, fair enough. No, I agree with that 1,000%, Justice Gallo. That's exactly why the letter was written. Okay. Yes, exactly. Yeah, because we could have just said, oh, well, here's an interview and go mad. No. The public protector did the responsible thing because of what you're saying, Justice Gallo. To say, well, maybe, you get ambushed by journalists and so on, and you're answering on the spur of the moment. Let's write a letter and ask the questions nicely, set them out nicely. And that you'll find at PN7.
Page 77.
Page 77. Thank you, I'm in the text of your lordship. That letter, it's a nice letter. It's not a fighting letter. It says the response, because remember, after this, what makes it worse now is that a few days after this, you get not a few days, the following day, we then get the letter from the Chief Justice, which says there is an investigation and so on, and thanking the parties for bringing it to their attention. So she says very nicely, we have no intention of engaging in endless correspondence before the completion of the ongoing investigation. I'm reading from 77. But your letter raises more questions than answers, as indicated below. The answers to such questions are essential, and they may have far-reaching implications on the serious issues arising out of this matter. We therefore instructed by the Public Protector to urgently respond to as follows. First one, it's about the investigation. Who will conduct the investigation? What is the scope and terms of reference? What's the nature and procedure of the investigation? Are witnesses going to be called? Who are the witnesses? Will the Public Protector be called to give an input or share her own investigation into the matter? Will the findings of the outcome be shared with the parties and the public simultaneously? Very fair questions. But then if you go to paragraph 8, paragraph 7, sorry, what is even more perplexing is that in his television interview, the Chief Justice stated that the Constitutional Court may have made a decision referred to by Mr. Abraham G. in his absence, quote, during the time that he had been in meetings. And then paragraph 8 says, these statements do not make sense in light of the applicable rules. They raise, among others, the following pertinent questions which need to be clarified. Really, for someone to ask for clarity and be faulted for that. It says 8.1. As it so appears, has a decision already been taken that the matter is only awaiting an outcome? That is, without, 1, issuing the Chief Justice's directions in terms of Rule 18 or requiring the Speaker to submit answering affidavit. If so, when and on what specific date was that decision taken? And then 8.3, has another decision been made to dismiss the rescission application, albeit in the absence and without the knowledge of the Chief Justice? 8.4, by whom was that decision taken? 8.5, if so, who, apart from the Chief Justice, could have taken a decision to dismiss the application without the knowledge of the Chief Justice? And how is it that even a possibility in view of the clear, how is that even a possibility in view of the clear wording of the requirements of Rule 18? 8.6, is the factual position that no decision has been made underlined, or merely that the decision has not been announced and underlined, which is unclear from the thing. And that's the most important one. In terms of the Constitutional Court, is it permissible for an outcome as indicated by the Chief Justice without the Chief Justice having given any directions, or even worse, without his knowledge? The important question there is 8.6. Is the factual position that no decision has been made, or merely that the decision has not been announced? Could have been, again, for the 4th or 5th or 6th time, a simple answer of saying, no, you got it wrong. There's no confusion. The decision has been made, but not announced, or the decision has not been made and not announced. In fact, the issue of announcement would be irrelevant, quite frankly, if the decision has not been made. That's just common sense. So to invoke the issue of announcement alone raises the specter that there's a decision. But be that as it may, the answer that we got from this was simply to say, we want to engage when seeking that clarity.
The answer and the order come at the same time.
No, the answer came on the 6th. I don't know which came first, but they came on the same day.
Signed by the same person, by Stephen Cindy.
Yes.
Both were signed by that person.
Yes.
They both date stamped with the Constitutional Court Registrar's date stamp on the same day.
Yeah.
And I take it was sent via electronic means. So
I don't know, but let's assume that is so. To move on, let's assume
it was
simultaneous. Let's assume it came.
It was sent simultaneously.
Yes.
I don't know.
But
when one looks at the second part of the reply, it says we stand by our letter of the 29th.
Yeah,
I'm paraphrasing.
Yeah.
And then if you go to the letter of the 29th, insofar as it relates to the allegations, they say it's currently being investigated, and then says the
decision will be announced. So
that will be communicated to the parties when the court has finalized its processes and made its decision.
Yes, that's true. But that's why I'm saying, let's assume in their favor, whoever was sending this thing, that it was sent simultaneously from literal or in whatever sequence. That's not what I'm busy with. I'm saying that the point about the decision which was given is one thing, all right? The issue about the investigation of how the decision was leaked to Mr. Abraham G is quite another, all right? So it doesn't matter what sequence the letters. I'm sorry, just sort of.
You say these are two different things.
Yes.
What
should, different processes.
What should concern us then? Is it the outcome or the legal?
No. Thank you. That's a very good question. With respect to Justice Timo. What should concern you is a situation where there is a possibility, and I will not put it higher than that. There is a possibility out there that somebody in the Constitutional Court leaked a judgment to influence this court, with respect. Not out of fun or as a joyride, but to influence the 3 justices sitting here. If that was not the case, that SMS would not have been sent to Advocate Breitenbach. It would have been sent to me, Suku, or whoever. It is a deliberate act of criminality and corruption to take that information. In terms of the definition of corruption in our law, Section 3 of the Corruption Act and Section 8, which deals with judicial officers, corruption in relation to judicial officers, say that if there is any activity which suggests, and this is how it becomes corruption, Justice Tolam. As far as Mr. Abraham G is concerned, obviously it's corruption and scandalizing the court. There's no doubt about that. The common law crime of contempt of court. But as far as his source is concerned, whoever that might be, and we don't know, it could be a clerk, it could be someone in the registrar's office, it could be a judge, it could be anybody, we don't know. That's what the public protector says. As far as that person in the deep throat inside the court is concerned, it's an act of corruption. There is no doubt about that. There can be no doubt about it. Right? Now, but it's not the point to answer your question directly. It's not an act of corruption in the air. It's an act of corruption to influence this court. Because the only reason why Mr. Abraham G sends this to Mr. Breitenbach is to advantage Mr. Malene Friend. Malene Friend, Mr. Breitenbach is just a conduit. He has no part in this. It could have been anybody. It could have been Council van der Merwe or anybody else. So he's not the target. The target is the speaker and the committee that Mr. Breitenbach acts for. Is to advantage them. By the same token, it's not to disadvantage me. It's to disadvantage the public protector. Right? So those are the parties before this court. And for those 2 reasons, because it was to influence you and to influence the outcome of this process, and also to advantage one party over the other, it should concern you. Not that you should, obviously all of us are in the same boat. The investigation and its outcomes and the police and what have you, that's, this court cannot do anything about that. But to try and argue that that's a side issue, that is not, I mean, the committee even says, no, that has nothing to do with us. How can it have nothing to do with them when it was given to their advocate for their benefit? But anyway, that's as far as that issue is concerned. Coming to the issue of the I will start with the issue of this interpretation, right, of section 194.3a. I do that deliberately because that issue covers both, or not both, all the respondents except for the DP, unlike the conflict issue which only covers the president. Right. So let me explain again, Justice Dolamo. It's linked to what you're asking me. Why must this concern you, all these shenanigans? It is because there is clearly, and I say this with no fear of contradiction, because that's what the public protector says in their affidavit, that what seems to be happening here, if you cut out all the nice English words, is that one woman, is being, in a coordinated fashion, victimized by the most powerful forces in this country ever to be imagined. The head of state, no higher force there is than that. The OMCJ explained it in the Nkandla judgment. He is a constitutional being, all our hopes are on him. The Speaker of Parliament, the head of the legislature, we've said what we said about him. The Chief Justice, the head of the judicial, is, I've said what I'm saying about him. Bearing in mind that it is also mentioned in the main, before Mr. Abramji's thing anyway, in terms of the conflict to come to. And really, now, the NGOs are not even going there in the media, but who are represented collectively by Mr. Abramji. So you've got, which is called the fourth estate in colloquial language. So you've got all the four estates of the state, imaginable, top, except for Mr. Abramji, the heads of those things. Against a lonesome woman who's just trying to do her job. So her perception is that the entire network, not even mention the chair of the committee, that's another story. But that whole network is loaded against her. How can a court of justice, not a court of law, court of justice, not take that into account? To say, wait a minute, what is actually happening here? We've got all these papers and all that, but let's take a breath and a break. What is actually going on here? That it will be your privilege. But the point I'm making is, going back to section 194.3a, is that section, it is very clear that it is triggered at the point at which the start of the proceedings happens. In fact, it's even worse than that, because the Constitution uses the word after. So it's not even upon. Remember 177.3 that I read about the judges. Just says upon being reaching a particular stage. Here it says after the start of the proceedings. And we must accept or assume that the founding mothers and fathers of the Constitution knew what they were doing when they were affording the public protector that kind of protection. To say she can only be suspended after the start of the proceedings for their removal. It's a deliberate protection, which is higher than that of the judge. and which is, well, the president has no suspension provision. But the words do not just fall from the sky. What do they mean by after the start of the proceedings? Here, you're going to see the most blatant dishonesty in dealing with this question. And I say those words advisedly. The president, let's start with him, said to one of his to a Mr. Hoffman, yeah. 555 or 525. I'll paraphrase for now. The president said to Mr. Hoffman in January last year, 3 things. I cannot, Mr. Hoffman was agitating like everyone else for the suspension of the public protector in January last year already. The president said 3 things which are very interesting. He said, I cannot suspend because I'm conflicted. Okay? That's paraphrasing. Secondly, I cannot suspend because the proceedings have not started, and therefore section 194.3a is not triggered. Those are his words. Life is low. Just the one volume you're looking for. The one that you're looking for. Anyway, he says that, which means 2 things, that the president was aware, fully aware of these 2 issues that we raise here, that conflict of interest and the triggering of 194 are an impediment to suspending. Yes. Okay. Now, the letter starts at 524.
Page 5 to
524, yes, and goes on to 525. Volume 6, I'm sorry, my lord.
in the main.
In the main pleading Spaniard, that's correct. Paragraph 3, this is the president writing to Mr. Hoffman, Mr. Sandam Pine, acting director and secretary for the cabinet and so on behalf of the presidency. You see in the letter at 524. In your emails, you suggest that the president has a discretionary power under section 194.3 and so on, I'll jump to 3. You are correct in raising the possibility of a conflict of interest in your latest email. Kindly be informed that the president gave an undertaking to the Western Cape High Court I'm sorry, Western Cape High Court pending matter case number 2107/2020. That's where the connection between that matter and this one really is. Where the public protector is challenging, amongst other things, the validity of the rules adopted by the National Assembly for removal of the heads of commissioners, chapter 9 institution. The President's undertaking is that he will not exercise powers under section 194(3), while the Constitutional Court has not delivered its judgment on pending litigation between the President and the public protector, and will delegate the exercise of the power to another member of cabinet.
Now, besides this case, where the President is also responding, is there any other pending, and of course the rescission application, is there any other pending litigation?
I'll come to that just now. Can I finish? The President has considered your request, but has not delegated this consideration to another member, because no proceedings by a committee of the National Assembly has set up to consider the removal of the public protector have commenced. In other words, section 194(3)(a) of the Constitution is not engaged at this stage, and I will show that that we are still there now. And then here's the interesting one, which shows the conspiracy and the what I call the network. It says, furthermore, that's paragraph 6. The President will not be involved in the processes of the National Assembly considering the removal of the public protector. He will have to wait for a request from the Speaker, as contemplated in the rules, and there's no such thing in the rules, before he can consider exercising the powers under 194(3)(a) of the Constitution. In the Speaker's request, the President will be provided with a copy of the independent panel and so on and so on. But let's start there before I come to your question, Justice. This, what he's saying at paragraph 6, is exactly what happened on the 10th of March, where he was being obviously prompted by the Speaker to suspend. That's why he said he won't just wake up and do it. The Speaker will have to request it. But now the request is couched dishonestly as a so-called courtesy letter. Okay. But this is what the President said he would wait for. Let's move with it slowly. Section 194(3)(a), let's flag that up. We'll come to that. Let's come to Justice Erasmus's question. And that is there any pending litigation? The first answer is yes. The second answer is it doesn't matter. Let me explain. There is pending litigation in the sense that the real question about the President's involvement in the Busasa scandal, CR17 scandal, is yet to be answered when the pending litigation around the unsealing of those documents is finalized. So it's pending in that sense, common cause, there's no debate about that. The question is what do we contend to be the implications of that? If you read any of the judgments, High Court judgment of Mlambo, JP and others, and the Concord judgment, well, even anybody in the street knows this. The gist of why the courts said that the public protector does not have jurisdiction over that matter was because they say it is a personal donation to do with the ANC and not a public. That you have to believe. So that was the gist of the thing. In other words, there was no, from the donors, there was no expectation that he'll become the president of the country. It was just, they were just being generous to a member of a party. And who? He became the president of the country. Fine. So that's the gist. Now, the reason why that theory can even be sustained, I mean, ridiculous in the affidavit, it's even expanded by various people in ways that I don't want to go into. But the only reason why our courts believe that theory, and we can't blame the courts, is because the documents were sealed. What was the court going to do? The court cannot agree that Mr. Masuku donated the money for nefarious purposes because the documents are sealed. So the case, the pending case now about the unsealing of the documents is directly related to the conflict that the president suffers. In other words, in simple terms, if that court says that let's expose the Mr. Masukus of this world, and it comes out of that unsealing that Mr. Masuku indeed, for not very holy reasons, donated them. And Mr. Masuku was expecting to get a tender, for example.
I have to object on behalf of Mr. Masuku.
Objection sustained.
I was waiting to discover
from him, yes.
more about Mr. Masuku.
Well, Mr. Masuku unfortunately happens to be my junior in another matter, so I'm sure he had to constrain himself. Thank you, Justice Bill.
I was not going to object. This
yes, let's just call Mr. X. Mr. X. If it is found that Mr. X donated for the purposes of securing tenders, for argument's sake, then immediately the jurisdiction of the public protector is engaged. So the entire edifice of the so-called finality in the Busasa judgments will fall away, because that judgment will unveil the donors of the 1 billion rand. And so so that's the first answer, that they actually, if you look beyond the obvious, that matter is not by any stretch of the imagination. One day, those documents will be unsealed. But let's put that aside. Let's assume I'm wrong about that. Okay? Let's assume that Mr. X and the donations and this is the end of the matter forever. Amen. Let's assume that, make that incorrect assumption. Then it comes to Justice Erasmus's question, and this I have to say very slowly. If Mr. Mpofu, you are saying, let's assume that the Busasa thing will never be reopened, then, or that there's no possibility that the court in the next 2 weeks might actually unseal the documents, which might happen, by the way. The SCA might say it might be unsealed, or the Concord or whatever. But let's assume I'm wrong. Then what is left? It is the 3 pending investigations by the public protector. The one is the allegations of judicial capture involving the president on one of the complaints. The other one is the allegation of the Zimbabwe trip, where by some coincidence, the speaker, the current speaker, when she was still Minister of Defense, took her friends from the ANC on a trip to Zimbabwe on a government aeroplane. Again, we must assume this is a coincidence. It's the same person, by the way, to go back to Justice Vela's question. It's not the office of the speaker, it's Ms. Kabula. That person, who is part of the network I've just explained, is being investigated for having flouted the law, and in fact, she has even been sanctioned by the president. for doing that. So that's ongoing investigation number 2, right? The third ongoing investigation involves the president in the Scopa matter, where he said in a meeting that he was aware of people abusing public funds to run ANC errands. Those are 3 ongoing investigations. It is common cause.
Now, assuming we are with you, on the president is conflicted, and assuming we are with you that the
process has not started.
Have not started. What will be the effect thereof on the work of the Section 194 committee?
Very good. Thank you. I'm sorry, Judge Delama, I'm not patronizing. I'm just, it's because it just comes to what was my next one. I apologize. If I may, please, Justice Delama, beg you, if can I just pack that just to finish the question of Justice Erasmus? Sorry, I'll write it down so I don't forget your question. Right. Here's the thing. The source of the conflict, the admitted conflict by the president of South Africa, which he indicates to Mr. Hoffman and others, is not so much the fact that there is pending litigation. It is the implications thereof. He says in one of his affidavits, I can understand why someone might think that if there is this pending litigation and the adversary, then I might want to get rid, quote unquote. I hope I'm not misquoting the president. I might want to get rid of that person who's my rival. I must emphasize that sorry. Yeah, you'll find that at page 204 of volume 3. He says under oath, paragraph 26, I respectfully say and accept that a potential conflict of interest arises from the pending litigation between the public protector and I, not the findings that the public protector made against me. In recognition of this, I accept that I am duty bound, right, to act so as to exclude the possibility or the perception of bias affecting the outcome of any decision that I may make in relation to my powers under Section 194(3) of the Constitution. Here's the sting. This is necessary in order to protect the integrity and legitimacy of the Constitution and the process followed in relation thereto. I can assure you that those words come from one of the cases in the Big Five, which is the president versus the public protector. That's the Gauteng case, the so-called state of capture. By the way, if I may just pause then and just give you these cases quickly, the so-called Big Five cases. Case 1, I said, was the impeachment case. That is 2018-2571. That's economic freedom fighters versus the speaker. Case number 2 is the Nkanta case. That's the EFF versus the speaker. You'll find that at 2016, bracket 3580, and in our case list, I'll refer to. Case number 3 is the UDM case. That's the I referred to it earlier, and that is case number 90 in file number 5. Nkanka is case number 3. That's 2016 bracket 3580 CC. And UDM, which is case number 3, you'll find is case number 90, which you'll find at 1992 of the bundle of cases. That one is 2017 5 SA 300. And then case number 4 is this one that we're dealing with now. President versus Public Protector, 2018 bracket 2 160. That's case number 18 on the list. That was case number 4. Yes, and case number 5 is the judgment of the Constitutional Court in this matter. That's the Mhlahla J judgment. That you will find it appears twice at page 97 of volume 2, but also at page 1938 of the other volumes. So the words that the president, to come back to Justice Erasmus, was saying here come from there. And the importance is this, Justice Erasmus. There are 3 forms of conflict that affect you if you are the president of the country. The first one is the one that affects everyone else, me and everyone, an actual conflict. If I'm conflicted, I'm sitting in a board meeting, I must recuse. The second one is the potential or reasonably apprehended conflict by the victim of that conflict, for lack of a better word. But the third one, which is important, is the one that arises from section 96(2)(b) of the Constitution. That one is special because it's not like the conflicts that arise like everyone else. It only arises by you accepting to become a member of the cabinet, like the president. And that's the importance of this, Justice Erasmus. It says members of the cabinet, and that includes the president, may not act in any way that is inconsistent with their office. That's the first thing. It may not breach the oath of office, for example. Or, which is a separate thing, expose themselves to any situation involving the risk of a conflict between their official responsibilities and private interests. The risk. Justice Mkhwebane explained this in the Gallo judgment. He said the risk doesn't even have to eventuate. The risk is enough. And that's what the president himself was alluding to when he says, I will recuse myself so as to exclude that risk or that possibility. So this is the reality of the situation, Justice Erasmus. If we accept that there are 3, for now, let's say there's no pending litigation, but there are 3 ongoing investigations, which is common cause. Then I'll ask this rhetorical question. Which one is more likely to raise a conflict? Which one, really? Between ongoing litigation, where you are the respondent, what's the worst thing that can happen? Maybe you'll get a court order against yourself. If that raises a potential conflict, how on earth can 3 investigations relating to 3 serious offenses, impeachable offenses, each one would have been enough, but 3, all of them may result in the impeachment of the president. Which one is the calamity that would raise a conflict? Is it because it's a respondent in some litigation on Musasa, or the fact that he is in jeopardy of losing his job? Please, let's the situation that the president is facing as a result of, in fact, Justice Erasmus, let's do this exercise. For the word litigation, I'll use the word investigation, just to emphasize this point. Then this is what the President is saying. I respectfully say and accept that a potential conflict of interest arises from the pending litigation, he says, and I say investigation, between the public protector and I, not the findings, whatever. In recognition of these three things, I accept that I'm duty-bound to act so as to exclude the possibility or the perception, or you might add the risk of bias affecting the outcome of any decision that I may take in relation to my powers under 194(3) of the Constitution. This is necessary in order to protect the integrity and legitimacy of the Constitution and process followed in relation thereto. It's what we lawyers call a fortiori. If he perceives a risk by his status as a respondent in litigation, then a fortiori, he must perceive the same risk in relation to 3 impeachable serious offenses. Because those could even be criminal offenses, by the way. So the thing about being a respondent is chicken feed compared to what the real, it makes the Busasa so-called risk Sunday picnic compared to what it is. So there is no way that the President, on his own words, is empowered or entitled to the suspending authority. He said it to Mr. Hoffman, he said it under oath. So unlike the other thing about saying things in an interview, no. These are things that were said advisedly and under oath to this court. So again, he says in paragraph 29 to page 205, what sets this matter apart and gives rise to the conflict of interest? See now, he's not even talking about the potential, he's talking about an actual conflict. So what sets this matter apart and gives rise to the conflict of interest on my part, so to speak, is that there is pending litigation that is underway between the public protector and I, which is unlikely to be resolved by the time the proceedings under the impeachment rules commence. Again, simply replace the word investigations there for pending litigation. In other words, pending serious investigations on impeachable offenses.
How will the suspension of the incumbent to the office of the public protector prevent the office of the public protector from continuing to investigate the president in connection with those 3 incidents that you have highlighted?
Nothing, but that's not the question. Nothing will prevent them. The question is not whether, that's like saying, let's assume the public protector's term was ending next week. Then obviously the new public protector would continue.
Or the deputy.
Or the deputy, or anyone, let's say 1,000 other people. That's not the question. The question is what the president himself emphasized, has said, that if, again, let's revert to this, Advocate Mkhwebane.
Because it makes no difference to the president, why would you say there's a reasonable apprehension of bias?
It's not me, it's the president. The president says to this court under oath that that question should have been asked to him, not me, when he wrote this affidavit. That why are you saying that if there is this pending litigation, surely you can suspend the person and simply the deputy will be the applicant?
When you say he says under oath, where is that?
Okay, that is part, the 2 parts I've just read to you. The first one is page 204, my lord.
But you haven't read from his affidavit.
That's what I was reading from, by the way.
From the previous affidavit.
Yes, look at, it's 2 of them, by the way. 192, my lord. Page 192. It's called second respondent's explanatory affidavit. And then the next page it says, I, the undersigned Matamela Cyril Ramaphosa, make the following statement under oath.
I'm with you.
Oh, okay.
This wasn't this case.
Well, it's an oath to God, my lord. It doesn't
No.
matter what case
When
it
you
is.
say he made the affidavit in this case, that's why I'm asking.
No,
Because his
what did you say in this
in
case?
this case is from
I never said
the
that.
300s.
I never said that, my lord. You are the one who said, let's go to the Saldana case. It was in the Saldana
In the
case.
Saldana case.
Yes. So, what I'm saying is that he said it under oath to God, the same God. God was the same before the Saldana case and now. So he said, I, under oath, make the following statement. That I respectfully say that I accept that a potential conflict of interest arises from the pending litigation. He said, paragraph 29, what sets this matter apart gives me the conflict of interest. That was, my lord, on the 17th. If you go to page 210.
I'm with you. But he also dealt with the conflict of interest issues in the latest affidavit, where the four issues,
Yes, but that's,
in this case before us,
you may or
the
may
public
not.
protector raised four issues.
Yeah.
It's the Bosasa issue, it's the issue of the Zimbabwe plane, it's the
So-called judicial capture.
yeah, I'm getting to that as the last one, and the leaked audio, the Mervyn Dirks.
The stopper, yes, correct. Yeah. But
So-
that's not what I'm talking about.
And then he gives an explanation there. This is now on the founding affidavit in Parliament. I know that there were undertakings in some of the previous affidavits. He actually said under oath, I'll delegate if needs be.
Yeah, so I don't
But in
understand what
this
is the
particular
problem now.
matter,
In this matter.
let's deal with the conflict of interest issues as it's on the evidence before us in this case.
Right. That's what I'm doing. I'm saying to you, to your lordships, the conflict of interest. Remember, okay. Let's go to volume 1, which is the affidavit of the public protector in this matter, as you said. The public protector simply says, and by the way, unfortunately, it just sends us full circle. This matter,
Yeah.
page 26. Starting at page 25. Public protector says, in actual fact, the president himself has previously, under oath, that's all the only point I was making, in an affidavit filed in Part A of the application that was heard by this Honorable Court in October 2020, considered and accepted that a potential conflict of interest arises from the pending litigation between himself and me. In that affidavit, he states inter alia, and then it reads what I've just read to you.
No, that's uncontentious.
Yeah.
It's common
Well,
cause.
that's what I'm saying. I don't understand where the problem is, because that's what she, in this case, in other words, let's forget about the Southern case. In this case, she has raised this paragraph 61.1, 61.2, 61.3, and 63. This is 1.3, which is the part I had not read. She quotes the public protector. To the extent that the delegation would still be permissible, then it must be made clear that the order operates against me personally and will not affect the authority to delegate the exercise of the power under Section 194.3 of the Constitution to another member of Cabinet who is not tainted by similar conflict of interest. In other words, who is not tainted by similar conflict as me, right? as the court will determine exists in relation to my pending litigation. So whether it's that case or that case or that case, he under oath, I state by that, he under oath considered to a conflict, which is exactly what is being invoked by the public protector. He is legally disqualified from having anything to do with this suspension. Legally disqualified. We should not even be debating this, because the president himself, I'm not quoting some person or some expert, I'm quoting President Ramaphosa himself.
But all that
I'm sorry, Justice.
Let me understand this. All that the relief says, and all that you saying you want relief for on behalf of the applicant is the letter, the president is prohibited from taking any steps in pursuance of the suspension of the applicant, and the president is mandated to withdraw his letter dated so and so.
I'm sorry, I'm just going there. Yes, you are on page 2, yes.
Well, I've got it correctly. So the president is mandated to withdraw his letter to the applicant.
Yeah.
Now, in that letter, it's only asking the applicant for reasons why she should not be suspended. It's not suspending her.
Yes.
So say the applicant had to write back to him and say, "Dear Mr. President, I refer to all the previous correspondence, all the other affidavits that you made, and you can't suspend me because you are conflicted for the following reasons, A, B, C, D, E, F, G." The president may say, "I agree with you," and then delegate.
So before you answer, Mr. Prof, just maybe for you to give us a complete answer, because there was an affidavit filed last night when it stated that the public protector had already answered to the letter of the president partially, dealing with the conflict issue. So there was a part A answer. There was such an affidavit filed last night.
Then I don't have to answer the question. That's the answer to the Justice Gallo's question. Where he says, say that the public protector wrote to him and say, "We are conflicted," and so on. But that's exactly what happened. Go to the Alistair BMS, I think it's 18. It's in the letter written.
So my point is this:
on the
we may be agreeing with each other. My point is this: do you still require the relief you seek on behalf of the applicant in paragraph 1.5 of your submission?
Yes, Justice Gallo. Why do I seek the relief?
Why do you still receive?
Yes, let me explain to you why I seek it.
Yes.
Okay, there's something called a letter of demand, right? So we write to the president as you propose. Okay, you say you are conflicted, step away. I think those were the words we used. Step away or step aside from this thing because you are conflicted. The president writes back, I'll find you have the additions. He says, "No, you are wrong, public protector." What is that called? A legal dispute. Because if we write a letter and it says, I remember actually I said this under oath and so on, and I also said it to Mr. Hoffman, then your question would be valid. But we did exactly what you are advising us to do. And he disputes it. That's why we are before you. The three of you must now resolve that dispute between the public protector and the president. That's all. It's that simple.
So show me in the record where he disputes it.
Okay. I think it's the volume.
That is conflicted.
The volume 2.
Volume 2, you say?
Volume 2, yes.
His affidavit in this matter is to be found on page 309 and further in volume 4. And it deals with that issue on page 328 and further.
In his, yes,
From
his
paragraph 28 of his affidavit under heading E.
That's correct, my lord. But no, but
And
Justice
he said, I'm
Zeller's
only
question,
going to deal with these 4 issues.
and I'm not going to whatever. So Mr. No, yes, no, I accept that, my lord. But I'm answering the specific question of Justice Zeller. I'm saying that, and he says I must show him, I'll show him the letter, that we did the right thing. We've been begging these people. We sent a letter to say, please, in the spirit of Section 41 of the Constitution, let us avoid the litigation, do the right thing, and so on and so on. Even yesterday, as you correctly say, 2 days ago, we wrote another letter to the president. We said, please, you said in that letter of the 22nd of March, there's not enough detail about these so-called investigations. Now, the investigations are there. Now you've got the details in the pleadings. Now you've got the benefit of all these quotations from what you said earlier. Please, we beg you, sir, step away from this so that in 2 days' time, which is today, when we come here, all I would have said is, my lords, this case is now going to take 1 day because the president has done the right thing and he's delegated the suspension.
Well, at the pace we're going, we might still be a Friday and Monday.
And whatever.
And that's why I
it takes.
indicated to the parties yesterday we're running a continuous
Yes,
road.
it was also
We're
with
gonna
that.
sit until we're done.
Yeah, it was, we will.
No postponements or breaks.
No, there won't
Except
be.
for the weekend.
No, we don't want, they must bring it as quickly as possible, but lawfully. So the issue is this, and it was with that in mind, Justice Erasmus, that we made this plea 2 days ago. It was to save you from having to tell me what you've just told me now. And we said, please, you, Mr. President, are the supreme being, or whatever Justice Mkhwebane said in the Gallo case. You are the embodiment of the Constitution. Forget the Speaker, forget Mr. Janchi. You, Mr. President, have a duty now, having seen all this, to say, I'm stepping aside from this thing, and I will honor what I said to God earlier, that I will step aside from this while standing. He refused again, Justice Gallo. Not so. Forget the annexure that I'm going to show you now. He refused again 2 days ago, yesterday actually.
I think Mr. Owen, they coincidentally just came on now. It's Mr. Owen in his affidavit, the one that was filed last night, indicated that they were willing to give further extension on the so-called Part B of the answers, because he's now dealt with a conflict.
Yeah, well, that may well be so. What I'm addressing now is the question as to why are we asking for the president to recuse himself from you. I'm saying that he said at page 271, we do not agree that the president is disqualified for the reasons alleged in your letter. In particular, and then it goes on and on. And then we explain to him that, sorry, that letter is, it started, it's BMS 13B, it started 268. That was a response to our letter of demand, which is quite detailed about the conflicts, which starts at 258, written on the 23rd of March. Okay? So that was the first letter of demand in volume 3. Then, as I said, 2 days ago, we wrote him another one, another pleading letter, on our knees again to say, so it's twice Justice Philip. Now, the question you were asking is,
you still want the relief of drawing the letter?
Yes, we do.
Or letter being withdrawn?
Yes, the letter, but yes.
Besides the fact there's been correspondence since that letter.
Yes, please. I'll explain why. But that's not you may or may not give that relief. Quite frankly, I'm neutral about it. The important issue is that the president must be interdicted from participating in a situation where he's conflicted. How it's framed is no skin off my nose. I'm not, the letter, the importance of the letter, Justice Gallo, is simply that, and I'll demonstrate that when I go to this issue about the 22nd and so on, is that that letter is an act of illegality, particularly from a president who knows, what he has said before under oath. And it's also an act of illegality because it stems from another act of illegality, which is the letter of Mr. Mapisa of the 10th of June, which comes from another illegality, which is the meeting of the 22nd of February 2022. That's how the letters come into the picture. Why do I say that? One day in South Africa, before the 22nd of February 2022, a certain Mr. Richard Danji woke up from wherever he was and decided that on the 22nd of February 2022, he's going to call a meeting of the committee. Just like that, himself alone. No discussion with anybody. I mean, is this a banana republic? No discussion with anyone, no consultation with the speaker, no consultation with the public protector, nothing.
Why will there be a consultation with the public protector if the argument that the process has not started should Mr. Janji consult the public prosecutor, the public protector?
Thank you, Justice Gallo. Well, I'm assuming you're asking that question on the basis that the process has not started.
On your version, you say the process has not started.
Yes, I know it's my version, but I'm assuming you're asking that question on that assumption.
If I made that assumption.
Correct. Okay. Well, firstly, if that assumption is held to be correct, the president is still disqualified for that reason alone. But we'll come to that. Why should
because it's still an internal matter. They can arrange their affairs as they feel.
Absolutely, it's a so-called pre-trial.
Yeah.
Thank you. That's exactly our argument. Our argument on the second leg is that at that stage, you see, Justice Dolam, what these people are saying to you is so untenable, and it's demonstrated by your question. You cannot have it both ways. You can't have your cake and eat it.
The thing is, the PP can't have the cake and eat it.
No, the PP can have 100 cakes because she can plead that he's disqualified. He's disqualified for conflict. If he's not disqualified by conflict, he's disqualified by age. If he's not disqualified by age, he's disqualified by citizenship. If he's not disqualified by citizenship, he's disqualified by gender. Whatever.
Mr. Mpofu, be careful, you might land up on TikTok or YouTube.
Yes, no, okay, well, that would be not so terrible. A litigant, an applicant, Justice Dolam, can come here and give you 10 alternative bases.
But it is for the bench to, at the end.
Yes,
that's a valid
It only
argument.
needs
So
one,
I'm testing whether that argument
Yes.
is valid.
No, but let's not say she cannot have alternative formulations, because
Okay.
that's wrong. But so let's come to the respondent. It is the respondent who cannot have the cake and eat it. Because unlike an applicant, a respondent cannot say, such as the president here, he cannot say what you're saying to me, which we are putting for the sake of debate. He can say, well, if you are saying that the proceedings had not started, then why do you want to be consulted? Because I just sit down and go home.
No, I was.
No. I
Yes.
understand. But I'm
Mr.
simply,
Jansi wakes up,
Yeah.
he calls his people and say, let's take the process forward.
we'll come back to that.
Yeah.
I just want to address this so that it's put to bed once and for all. Because we can't equate the cake, can't equate the respondent sitting on 2 stools and a applicant who can sit on 100. I'm saying, if the president were to stand up now and say, but Mr. Mpofu, this is ridiculous. You can't say you should be consulted because you said the thing has not started. Then I say, I'll pack my bags and go home. Because on that basis, that it has not started alone, the president is disqualified. I'm happy if that's what they say.
That will
So-
into my next question that you have packed.
Yes, I'll come to that. So here's the thing, Justice Dolamo. And this goes to, I'll come to your question, I promise. This goes to the heart of this question, of this case, all right? I don't know but it goes to the heart of this question, of this case. And that is the 5th case I spoke about in what I call the Big 5 cases, okay? Which is the Mhlahla J judgment.
In this matter.
Yes, in the Concord.
Yeah, in the Concord matter.
Yeah. You know, justices, if by now you don't realize that you are being, the smokes and mirrors and mirages, then nothing else will convince you than looking at the judgment of Mhlahla J, paragraph 110 thereof.
That's the one that, just for the record, it's the one that you're asking for the rescission of.
Paragraph 110, which is
The page in our bundles.
in the bundles, it is that will be 19.
In our case bundles.
Yes, in the case bundle, my lord, 1988
1988.
and 88. And by the way, yes,
The judgment starts in the 1800s.
that's correct, my lord.
1820, just for the record.
It's 1988,
And you want to go to paragraph
110.
110.
That paragraph, my lord, really makes it obvious that we should not be here, or any reasonable president or speaker or even chair of a committee should not be subjecting us to this process. Right. This is what the Constitutional Court said unanimously. And it goes to your question, this second question, Justice Dalam. Let me give you background to this. The Speaker and the DA were the appellants, as you know. had asked the Constitutional Court to make the order around legal representation to be retrospective, or rather to be prospective. In other words, not to operate as a normal court order, which is retrospective. That is in terms of Section 172B, Roman 1, as you know, that a court may affect the retrospectivity of the order for various reasons. I'm going to bore this court. So the Constitutional Court refused to give that prospective order, and it said the order will operate like any other order retrospectively. Are we still good?
Yeah.
Okay.
Just people going to come in and out of the platform.
Very important, this context. So, what is then the effect of the retrospectivity of that order? There's two devastating impacts. The first one is on the interpretation. This is what Justice Mkhwebane said. The office bearer is entitled to full legal representation at the stage of Section 194 inquiry, that is, during the inquiry before the committee established in terms of Rule 129AA. That answers your first question, Justice Delong. Why does she want to be consulted, or her lawyers? Because the Constitutional Court of this country said that she's entitled to full legal representation at the stage of Section 194 inquiry. That is during
that stage.
No.
Of the Section 194.
Yeah, which is where we are.
Yeah.
That is where we are.
Are you saying it has already started?
No. I am saying the Section 194 committee was established on the 16th of March 2021. That is common cause.
Yes.
Right? That committee had a meeting in July last year. Had a meeting, right? It had another meeting on the 28th of July last year. It had the controversial meeting of the 22nd of February this year. It had a meeting on the 29th of March, and it had a meeting last week on the 11th of May. All right, 5 meetings. Common cause. Okay. Now, the inquiry, and this is why we seem to have I don't know, that's logical or linguistic difficulties with the other side there. And this is where, with the greatest respect, Justice Gallo, I made this point with all seriousness, that they cannot have their cake and eat it. So it is either they are saying, no, that stage has not been reached for you to participate legally, because we're not there yet. Thank you. If that's what they're saying, then Section 194(3)(a) of this Constitution does not yet apply. Okay? Or they are saying that the thing has actually started. So that could be the. If they are saying that, then they have not complied with the injunction of Mkhwebane J to give us full legal representation. You cannot have it both ways. It's impossible. With the greatest of the greatest respects, that is the simple situation that these respondents are trying to play around in this court. You can't. There is no alternative. It's either the issue has not started, in which case the 194(3)(a) is not applicable, or it has started, but they've defied, they're in contempt of court, which is a criminal offense, punishable by 15 months these days. So,
Yes, you rescinded.
Unless of course. And then successfully, as Justice Chapter, who means very much in other contexts. As Justice Chapter said, that should have been rescinded. You're right, Justice Phil. Yes.
It's 4 minutes past 1.
Yes.
5 past 1. I'm going to take the custody break now.
Yes.
Until 2 o'clock.
Yes.
Will the people from the administration just inform the security front door that is starting at 2, so that they allow council into the building?
Lord, can I just beg literally for 1 or 2 minutes? I just want to run off this point so that I start with something else. Yes. And I'll make it cryptic now, and I may develop it. So the answer to all your problems, justices, lies in paragraph 110 of the Constitutional Court judgment, which, by the way, unlike the judgment of Saldanha J, is binding on you, because it is a judgment of the Apex Court. So that formulation, what Justice Nkanka was saying in normal language, is that I will not make this order retrospective because, Justice Tolama, we have not yet, the process has not started. Just continue. That's what she was saying. And therefore, your lawyer rights will kickstart when the process has started. What was the date when she said this? The 4th of February 2022. All these respondents tell you that the process started in 2021. They are wrong. And you have no way out of this judgment of the Constitutional Court on that issue.
Is this not the judgment you want to rescind?
Yeah, it is. And so, is that a serious?
That's my question before lunch, Mr.
Yes. No, the question is, the answer to that is the same judgment that you told me this morning is final.
No, but what you're saying is, in that paragraph, she postulated the inquiry only to start at a much later.
Yes.
Because we know as a fact, when the matter was in court the last time, you told us from the bar, and it's now an affidavit, that the so-called charges were only given to her that weekend preceding to the public protector.
Yes. Okay.
So she wasn't even served with the charges, so the Audi rule couldn't kick in before the hearing of the last time.
Yeah. No, that's correct. But let me just quickly dispose of what you just said now, very quickly, before lunch. I'm assuming that I don't know if you were just on a lighter note, but if that was serious, yes.
Let's put you in a lighter note.
Yes. Okay. Okay. No, then I won't. But if it was serious, we are not rescinding paragraph 110. Okay. In the rescission application, we are rescinding the issue about the judge participating in the panel. We can't rescind where we want. We can't rescind the order to do with legal representation. That would be nonsensical on our part.
We'll get to that application in the afternoon.
Yeah.
Because it goes much wider now, the application that was filed, than merely dealing with, let's call it the judge participation.
Correct.
It
Okay.
now deals with declaratory relief and so forth.
Okay. Well, before we go to lunch, let me just say I'm happy we are taking that application seriously because that application is the leg that I will start on when I deal with the section 172(1)(b). Again, we can't have it both ways. We can either say, how can you rescind the rescission and make the ridiculous jokes that are made by pseudo professors out there, or we can say, no, this is an application which is to rescind an order, in which case Mr. Masuku will have a lot to say about it, and so will I. But I promise. The last point I want to make is, so that we round off the pre-lunch things, except that I owe Justice Dolamo an answer, which I will give briefly when we start. Is take page 507, Justice. Just to round off the earlier point we were talking about the conflict.
507 of the main bundle.
Yes, that's volume 6, my lord. Just to show you the kind of trickery and dishonesty that we have around this case. Not only did the president make the concessions that I've referred to, but the DA, none other than the DA, we discovered, by the way, that the president, that the DA, this was also some, it's not some put in the speaker's summary, page 501. The DA, surprise, surprise, on the 16th of March, the day before the president sent us the letter of suspension, sent him a letter threatening him to bring him here to court, to compel him to suspend. That you'll find at 515. If the president insists on postponing his decision, it should. No. Yes, no, it is. It should be next week.
One of those long letters.
Yes, it's one of those letters. But the one
it's at page 508.
That's correct, my lord. 508.
14 of the letter.
Absolutely, my lord. Accordingly, my client demands that you suspend Advocate Mkhwebane by 25 March 2022, failing which it will approach the appropriate court for relief to compel you to act as the Constitution requires. No outer. Then at paragraph 13, they say, which is really, really incredulous. My client is aware that the public protector is currently considering a complaint against you, laid by Mr. Marvin Dix. It says Dix, it's actually Dex, D-I-R-K-S, MP. In its view, that complaint does not preclude you from suspending Advocate Mkhwebane. The case of a suspension is so overwhelming, and the complaint will continue to be pursued by the Deputy Public Protector, as Justice Willis point, who will act in Advocate Mkhwebane's position while she is suspended. But if it is your view that you are unable to act because of a potential conflict of interest, then you may ask the Deputy President to, just Deputy to Deputy, you may ask the Deputy President to act in terms of section 90, bracket 1, bracket B of the Constitution. But the pending complaint against you is no basis to avoid a decision on whether or not to suspend Advocate Mkhwebane. I'll explain the import of that letter after lunch. Because what the DA was saying, which is no longer saying now, singing a different tune, Mr. Steinmeier and in this update, was that we know that there is this potential conflict. If you feel that you are conflicted, then you can delegate. That's exactly what we are saying. But now it has been dishonestly changed, the message, to say that there's no ground for such refusal, as God pleases.
And we will still resume it.
Thank you, Madam. I'm indebted. I know I ate into your lunch.
This thing is off, no? Camera's off.
Maybe IT, please.
Yeah, IT. This is IT.
No.
But my lord, we have had discussions with my colleagues, and this is the proposal that between myself and Mr. Subu, we go on for the rest of the day until 5. And then the other side, between the two of them, they'll go from 9 to 4. And then I'll have the rest of the time for argument. They say for the fact that depending, I'll assess by the end of today if I might need a little bit of extra time. But broadly, this is the agreement.
So the idea this morning was Mr. Masuku was going to have an hour.
Yes.
So
originally it was an hour and a half, but this kind of proposal comes from the other side. I had discussions with them over the.
So between the two of you, if you are happy, Mr. Mpofu, we're going to try not to interrupt you too much, so that by 4 o'clock,
I can. Yes.
Hopefully before that, if you can stop and then Mr. Masuku will go on. We start at 9 in the morning between the three council, because they also overlap.
They overlap.
We can come, but we must finish by tomorrow.
Yes, no, we will finish by tomorrow. The only I'm taking over from Gallo now, representing Mr. Masuku. The only I know Mr. Masuku, at least he has told me that if I finish at 4, he will try to get into an hour, but it might be 10 minutes or whatever extra. But that will be.
Let's just remember that unfortunately going way beyond the normal working hours of the staff. We have now made arrangements that the registrars will leave at 4. And then somebody else will come in as a relief person from the admin downstairs to assist us here. For us, the bench, we don't have office hours. But we have to take into account that we have to deal with other staff members that have other commitments, etc.
Thank you, my Lord. Firstly, again, we are indebted to the court for that. And all I'm saying, and to my colleagues, by the way, for the cooperation over the lunch hour. The only thing I want to say is, just from all our experience, it's always better to overload the first day so that we know that we have flexibility on the second day. So we will try and find that. Thank you.
Then you may proceed.
Thank you very much, my Lord.
You first have to answer Judge Long's question.
Yes. Okay, I have partly answered that question, but let's just put it to bed. Judge Long's question was, okay, Mr. Go, let's assume that the conflict point is good. What is the connection between that and the activities of the committee? Am I correct? Yes, thank you. Thank you.
Yeah, you may proceed.
Okay, thank you. I'd rather lose a few minutes, but I don't have the full attention.
The reason for them looking for the registrar's office keys is because they're having another computer in my registrar's office, who unfortunately had to leave because of illness.
No, fine. Right. Okay. So we'll just confirm the question of Justice Gallo. The answer to that lies in, firstly, what was said. Okay, let me go back to what I call the chain reaction, Justice Gallo. Remember 22 to 2022. Now, what we said is that, and I think it was, you were reminding me before lunch that I was still giving the story of one day Mr. Janti woke up. I'll finish that story. But once I finish that story, it will be crystal clear that that meeting of 22 February 2022 was nothing but just a festival of illegality in its own force. Assume for now that I will convince the court of that. If that is correct, Justice Gallo, excuse me, then the letter, remember this is one continuum. The letter of the Speaker of the 10th of March actually quotes the meeting of the 22nd February. You remember it says, "Dear Mr. President, the committee said on the 22nd, they've adopted terms of reference or whatever. We'll get to that later." and therefore, to be honest to the Speaker, actually she didn't even say what the President seems to have read in the letter. She says that there is the only word that she used wrongly is resume. I'll come to that. I'll call it the fallacious resumption theory. She says it resumes. Let's put that together. Then on the 16th, we now know the DA then writes the letter that I ended up with before lunch, which says please suspend, suspend, suspend. And then on the 17th, the President suspends. He doesn't refer, in fairness to him, to the DA letter, because you see his answer to the DA, which is the next page of whatever I was doing, where he says the President has already acted. So despite all the accusations that I make about coordinated efforts, I'm not going to say that the President very quickly overnight on the 16th wrote the letter simply.
The answer to the VA includes the first paragraph to say the letter is dated the 16th but only received
on the 17th, yeah. Which comes back to your question about the registrar's thing. So it cuts both ways, Justice Erasmus. It might well be that that letter was received in the morning and responded to in the afternoon. But I'm saying I'm not making that argument, yes. I'm not making that argument. I'm just, in fact, for me, quite honestly, the only value of the letter of the DA.
Bring it now, just hold on. I just want to give this to Natalie quick.
Just mute Mr. Manuel. No, he muted himself. Okay.
Thank you. So I was saying, Justice Erasmus, the only value that I want to place on that letter is not some conspiracy thing that the President was being pulled by the nose by the DA. It is the paragraph 13 which I read earlier, which is that they were fully aware of the conflict issue, and suddenly they've changed the tune now. So that's the only reason I was discussing that. But now coming back to your question, Justice Gallo. So it's one transaction. It's the meeting of the 22nd, which gives birth to the letter of the 10th, which gives birth to the letter of the 17th. So you can look at it.
The letter of the 17th is the one.
It's the suspension that
to which the public prosecutor has responded.
Yes,
and said you have a conflict.
Yes, that is absolutely.
And hence, my brother Justice Vida's question: do you still want the relief in paragraph 1.5?
I do.
Because you have already responded to that letter.
The rule of law says that the courts are enjoined to set aside any conduct that is inconsistent with the Constitution. Right? Remember, let's go back to the picking. Remember that the relief that we seek, part of the relief we seek in Part B is the illegality of those two letters. And this is not as simple as the respondents want you to believe, that, oh, well, it's a letter, so what? No. It's conduct and a decision by a very serious functionary to do something, right, which has potential adverse consequences to us. So if, for example, this was a tender board and this fell under PAJA, and they took a decision to give the tender to X instead of B, the only legal basis upon which you would be saying, don't implement that tender, would be the fact that it's a decision of an administrative body which is adverse to us. By the same logic, the decision to threaten even, and Justice Gallo was making some this distinction between, and I think I also owe him an explanation, distinction between that letter being only a threat of suspension as opposed to a
well, let's deal with that now. Just so I understand this. I understand your argument.
Yes.
And your argument for me is cogent. The problem, the difference between the argument that you make and the factual circumstances of this particular matter, of this, the letter written by the President is not a letter which suspended the applicant, the incumbent to the applicant's office.
Fair enough.
The letter only is a letter asking for reasons.
Correct.
So that is my difficulty.
Okay.
That is the difficulty I have with your analogy with PAJA and tenders and so
Okay.
on. Because that's a totally different factual circumstance from what you are postulating.
Yes. No. Thank you, Justice Gallo.
It's just a letter saying, give me reasons.
Yes. Okay.
And
Unfortunately,
before you answer that,
Mhm.
let me just ask you this. Is the letter actually necessary under these circumstances? Does the President have to write a letter saying, give me reasons?
Yes.
Is it actually necessary? Because the public protector, the incumbent to the office of the public protector, is not an employee of the President.
Yes. Okay. Good. I'll answer both those questions. Let's start with the second one. Is the letter necessary? The answer is yes. But again, like one of the previous questions, the second answer is, so what? It doesn't matter. The most important thing, Justice Gallo, is that the President, in his wisdom, has decided to write the letter. So that's a concrete situation. Whether it's not, he could have done without it, well, it might be from the kindness of his heart. I don't know. But once, you see, the rule of law works like this. Once, as a public functionary, remember, you're not exercising your own power. You're exercising constitutional powers. So once, it's like the whole debate, I know, Justice Gallo, about estoppel, whether estoppel works in the public law. It works in the same way, at least in my estimation, in some of the cases, as it does in contract law. Why? Because once you have represented something, then you are bound by that something. So let's at least agree on the minimum that the President felt that justice or fairness demands that he writes the letter. Fine. Why did he do that? He's doing that because somebody, I'm sure, some lawyer or someone else, has advised him that in fairness, you can't just wake up and boom, say, I'm suspending you tomorrow. Of course, and you're quite right, Justice Gallo. Even if he had done that, we would still be here for the same reason. But he and we are very grateful to him for that. Did the right thing, the fairer thing, which is to say, give me reasons why I should not suspend you. And then if those reasons are good. In other words, he was saying, Section 194.3a uses the word may, right? The President is not compelled to suspend the public protector. So because that subsection uses the word may, what the President is saying in normal language is, I'm now going to exercise my discretion to suspend you or not. And I'm giving you Audi. I'm giving you an opportunity to influence me one way or the other. Okay, that's really all he was doing. And as you correctly point out, Justice Vele, that principle of fairness is more usually applied in labor law. But fairness is fairness. There's no such thing as fairness in labor law, fairness in this, fairness in that. Fairness is fairness. So in fairness, he decided to grant that opportunity for representations. So that's the question about the factual situation.
So doesn't that also go to his fact that he's not really biased because he's giving this person such a good opportunity to come and say why I shouldn't suspend you? That goes to the fact, objectively, to show that he's not biased.
No, I can never do that. Even
if he was biased, he would merely suspend the person.
No, he's not. He might be biased, but he's not stupid. Because if he does that, then I mean he would have made my case very easy. The fact that I might want to fire my Leonard Jr. Mr. Shivambu because he didn't give me a particular volume when I wanted it. The fact that I might be doing that because, not because of that volume thing, but because of something else, because he said something I didn't like yesterday, and therefore I'm biased. The mere fact that I said to him, listen, by 4 o'clock you must give me reasons why I mustn't fire you from this brief, does not mean I'm no longer biased. I'm just giving him a so-called long rope or whatever, or trying to do the right thing, or I might have gone to my lawyer quickly at lunchtime and they say, no, if we want to get rid of this Shivambu, let's give him until 2 o'clock. So the two things are completely foreign to each other. So what is true, Justice Vele, is that, and I mean, we can't second guess the president's motives at this level. What is true is that he was advised to be fair, to at least to appear to be fair or to be fair. But all sorts of employers, as you know, Justice Vele, all sorts of employers, biased and unbiased, always give the employee an opportunity to show cause, blah, blah, blah. They might take that letter and throw it in the waste paper basket. That's another matter. But it doesn't, the fact that they've asked for the letter is no antidote for their bias. So, once then the president grants the opportunity for the Audi, then unfortunately he's bound by it. That should be obvious. So let me make a wild example. Let's say the president gives 10 days, right? Says, in 10 days, show me why I should not suspend you. And then in day 7, he thinks, no, I think I agree with Justice Bill. This letter was not necessary. I'm suspending you right now. That would be sheer stupidity, which I'm sure we cannot accuse our president of. Because he would then invite the retort that you gave 10 days or whatever, and you just woke up one day in day 7 and decided to. No one can then say, no, but the 10 days itself was not necessary. It doesn't matter. Yes, as a matter of fact, given it. So that's the first answer to your question. The second leg, which is the real question, but that the letter is itself a suspension, but a corrective suspension. Right. Let's answer that one. The president I'm looking for. Okay, sorry, I'll find you the reference, Justice Bill. We say in the founding affidavit that the letter of the 17th triggered, and I stand corrected on the actual wording, but the sentiment is what I'm going to say. The letter triggered the suspension process. Very important. Okay. What do we mean by that? We mean that letter, as we all know, every employee knows, once you get that letter, the writing is on the wall. You can't say you are in the same situation as yesterday and when you received that letter. That's when people go and see their lawyers. When they receive that letter that says, show me cause in a week as to why I should not suspend you. Okay. All sorts of cases. Gradual. One case, Gradual, sorry, I'll get a reference, which I did in, it was about an employee of the Northwest Education. It's one of the leading cases now on suspension. At that point, in that case, once we received that letter, we went to the Labour Court and said, aha, nobody has given us. Actually, it's the exact opposite. Because they did not give us that letter, we went to the Labour Court to say, you can't just wake up and suspend us. And so the president was avoiding that. But what cannot be denied, Justice Gallo, is the fact that, and in fairness to the president, he concedes this in his answer affidavit, that the letter actually kick-started the suspension process. So all we're asking you, my lords, and is to say, the president has taken this step, has kindly given us a warning shot, if you like, instead of just shooting. Please stop him from shooting. Right? So,
but now you're asking for interdictory relief on the basis that please stop the president from shooting, but you don't know whether the president's going to shoot.
No.
Because if he may write back after receiving the representations from the incumbent to the public protector and say, listen, I've listened to what you've said, and under the circumstances, I've decided that it's probably better not to suspend. Yes. But now you're asking me for interdictory, you're asking this court for interdictory relief on a hypothetical situation that may or may not happen.
No, sir, no. Let me explain that again. We are asking you to stop the president. Let's say, for the purposes of this answer, Justice Gallo, assume that the president is conflicted. I'll show you the connection between the two. What we're saying to you is that stop the president, any president, okay? Any president, anybody actually. Stop anybody in the world from participating in a suspension process in terms of 194.3a for the reason that the proceedings have not started. Okay? So that relief is against anyone in the world. No human being on this earth, unless if they have to change this constitution, can suspend the public protector when the proceedings have not started. Okay? So that's what we're saying to you. But what we're saying more, assume, and that's why the different cake story and the alternative relief. Assume for a minute we're wrong about that. Then we're saying, stop President Ramaphosa. That's a different thing altogether. The first one is that nobody, whatever their name is, can suspend before the start of the proceedings. The second one, it says someone else might, deputy president or whatever can do it. But the first one, not even the deputy president or anyone can do it. The second one says, now, court stop President Ramaphosa specifically from suspending because he as a human being is conflicted. That conflict cannot be transferable to other people, as he correctly says under oath.
No, I'm with you, but you can't stop him from writing the letter, asking for reasons. That you can't stop him.
No. Okay.
Now, let's take away the commencement proceedings, or whether the proceedings have commenced. Now, let's take away that argument. Let's take away the argument that, talking about the argument of the alleged conflict of the president.
Yes.
He can't be conflicted in writing a person a letter asking the person for reasons.
You can.
There can't be a conflict.
Okay, let me explain that one. You can't be involved, right? That's the crux. That if you are conflicted, you can't be involved in a suspension process of a person against whom you are conflicted. Full stop. That should be clear to everyone. So the letter is neither here nor there. The letter, the significance of the letter is the fact that it is evidence of his involvement in a matter in which he is conflicted. And therefore, we're saying that letter is ipso facto illegal because it is an act, it's the fruits of a poisonous tree, right? The mere fact that he writes that letter means he no longer regards himself as conflicted, as he says in his letters, wrongly. If he thought he was still conflicted, he would not have written that letter. He would have called the deputy president or someone else and say, listen, remember that letter I wrote to Hoffman saying that I'm conflicted. Now I'm actually more conflicted, the answer I gave to Justice Rasmussen. Now I'm even more conflicted because there are now these 3 investigations of impeachable offences. Please, Mr. Deputy President, write the letter. The reason he did not do that, Justice Dillon, is because he considered himself to be legally competent to write the letter. He is not. Right? So that's the issue. The simple answer is that, and that is why the relief is couched in those terms, that he must be stopped from taking any further step. And you and I have had this exchange before, where I said, even if for some reason you don't give the relief by the letter, and I agreed with you, I still agree with you, that even if you don't give that relief because maybe you don't think it's an illegal fruit of a poisonous tree or whatever, I concede that once you give the relief that says he may not take any further step in this process, the result will, for our purposes at least, will practically be the same. Yes, that I have no qualms with. But that must never be allowed to interfere with the fact that the conduct of the president in writing that letter is illegal. And if it is illegal, when he knew that he is conflicted, and he, well, okay, let's be generous, and he should have known that the process has not started, because that's exactly what he said, then the letter itself is illegal. But, yeah. So, which goes back to Justice Dolamo's question, namely this. The connection between these things, when I say the fruit of a poisonous tree, the poisonous tree is, to go back to that fairy tale I was telling this morning, of the poisonous tree is that Mr. Janti woke up one day and decided to call a meeting. We stopped at that point, then we went to the question about why he didn't consult anybody. But the point I was making is simply this, Justice, Villain Justice Gallo. I'm sorry. It's this one. Yeah. No, it's not. Go to, stranger things I've never seen. This case stems from what is on page 726. Volume 8, my lord. From those paragraphs, you will see what I call, I don't know what to call it, a litany of illegality. Or to borrow from Mr. Janji himself, a festival of illegality. We spoke about the festival of letters. He didn't know about that other three fingers were pointing at him. Mr. Janji says, under oath, in this case.
What paragraph are you?
21, my lord.
Okay.
Says, fifth, the Constitutional Court delivered this judgment on the 4th of February. Or rather, after the Constitutional Court delivered its judgment on 4th January 2022, February, I'm sorry, 2022, at my instance, just pause there. The Section 194 committee met on 22 February 2022, famous 22. Let's just pause there. So, Mr. Janji is telling you, your lordships, that at his instance, not him, not the committee, not anyone, he decided to call the meeting of the 22nd. But it gets better.
Remember, it is after the Constitutional Court has delivered its judgment.
Yes, that's what the 4th of February is.
Yeah. That's so. On the 22nd of February, when after the judgment was delivered on the 4th of February, he calls the meeting on the 22nd of February. Was there anything that prohibits him from doing that? Because whatever would have restrained him being a pending matter in the Constitutional Court is now over.
Okay, I'll come to that. You'll see. Can I read on? It gets better. It actually answers part of your question. He says, on that day, the members of the committee considered the import of the CC's decision. That's number 2. I'll come to that. Let me deal with those 2 first. By doing this, you see, the law is a very exacting and demanding thing, especially if you are exercising not your power as a father of your household, but a public power. Mr. Janji cannot, my lord, does not have the constitutional power to do the 2 things. One, to call a meeting as an individual, let alone that actually he was involved in another illegality before, around the so-called suspension of the process. We'll come to that. I forgive him for that one because we acquiesced in it. but it was still, it doesn't make it any better. So put that aside. Remember, and I'm sorry to do this, I'll come to the question. Paragraph 20, look at what he says. Mr. Tinodi MP, who by the way is the star of the show here, because Mr. Tinodi is of the 3 speakers who dealt with this matter. Mr. Tinodi comes out with flying colors because it's a pity he was only the acting speaker, because he had at least the right idea. The other 2, the less said about than the third. Mr. Tinodi MP therefore recommended to me that Section 194 committee holds its work until the judgment the CC delivered its judgment. The old game of spots the difference. What's wrong with that? Mr. Tinodi was conveying to Mr. Janji, and later they tried to around this by making it look like it was a decision of the committee. No, surely Mr. Tinodi was recommending to Mr. Janji so that he can take it to the committee, and then a decision to suspend the process would be taken. Our Mr. Janji did nothing of the sort. He says, me, accepted Mr. Tinodi's recommendation and consequently did not convene a further meeting until after the CC had delivered its judgment. That was not a decision that he could take as I. It was a decision of the committee. But as I say, for that one we forgive him because we didn't challenge it. Let me put it that way.
But who convenes the meetings?
Yeah.
The chair, or in terms of the rules, I haven't checked.
Yeah, doesn't matter. It's like saying who convenes parliament. It's the speaker, obviously. But the fact that you are the chair of a, let me put it this way, they wouldn't be lying about it now and saying that was a committee decision if he was empowered.
The way I understand the timeline, somewhere in July they had a meeting. This is now July 2020. Yeah.
Yeah, on the 21st and the
28th.
Yes.
That was the last meeting.
Yes.
Then came the judgment.
Yes.
Then on the 7th of August, the acting speaker filed their application for leave to appeal to the Constitution. That's when the discussion took place in that time.
I know.
When Mr. Chinoli told him, listen, although we called it earlier today the Saldanha judgment, granted you the right to proceed, stop the proceedings, and then he decided, I'm not going to call another meeting.
Yes. But I know the
until
facts.
the 22nd.
Yeah. But,
Of February this year.
I'm saying I know the facts. All I'm saying is the following: on both occasions, that decision can never fall in any democracy that I know of on some single individual called Mr. Janji. The decision both to suspend and particularly the decision to suspend. They say now, you'll find in this case, they say no, that decision was taken by the committee. It's a lie. That decision was taken by Mr. Janji, and he says so in so many words. He says, I accepted Mr. Tinodi's recommendation. Never took it to the committee, never took it to anybody. And I will talk, when I talk about the UDM case, you will see why our constitution doesn't like things like this. Because you can bulldoze decisions just because you are in the majority. But the fact that you are in the, like this decision now, where they are saying they are continuing with the process, that decision is so flawed, fundamentally legally flawed. But it stands because, not because it's right, it stands because there are many. So the law doesn't work like that in a constitutional democracy. You can't, just because you are many, if we are sitting here, we say, let's vote that today is Friday, and then it's Friday. No, it doesn't matter how many we are. If what we're doing is wrong, it's wrong. The court, this court, I can't come here and say, my lord, you must find that it's Friday. And you say, why? I said, because we just voted on it. The court will say, no, Mr. Murphy, you are out of your mind. Correctly. Because the objective fact that today is Wednesday is what the court is asked to decide. So,
but Mr. Mpofu, I don't put the interpretation that you put on paragraph 21. It says fifth. After the CC delivered its judgment on 4 February, at my instance, there you're correct, the committee met. So all he did is got the committee together on the 20th, and then he says, and resumed its work. So he's talking about the committee resuming the committee's work, but he merely got them together. It's not saying that he took the decision. He took the decision to get the committee together. The committee then took the decision to resume the work. What's wrong with that?
Okay. Who took the decision that the committee must meet on the 22nd?
He says at my instance, the committee met.
Yes, on the 22nd.
So he called it together. He said, you must all come together, we must have a meeting. Yeah. The committee then decided to resume its work. Yeah. That's not the person who convened the meeting deciding to resume the work, it's the committee.
Okay. At that point, Justice Gallo, we know that the activities of the committee were suspended, all right?
Yes.
But, okay, voluntarily.
To await
yes.
the outcome.
Well, even on the outcome came on the 4th. Let's assume he did this on the 10th. Okay. Even then, the proceedings were suspended. It's a factor. That's a fact. Okay. What he did was to unsuspend the activities of the committee. Admittedly, as Justice Gallo points out, to convene them. But the point I'm making is a much simpler one. It is not his place, right?
Unsuspend.
To unsuspend.
Because it was voluntary. They suspended the proceedings because they
did
it necessary to wait. Voluntarily.
No, it was that part. The voluntary part is that they did not resist the recommendation of Mr. Tsinoli. But it is not as if Justice Tolamo, they woke up and said there's an appeal and therefore we're going to suspend. It's not that voluntariness. It actually shows another lie where the speaker, abdicating her power, says that it is not her baby to suspend.
In whose jurisdiction does the 194 process lie?
In the speaker
committee.
It's the speaker's subcommittee. It's a subcommittee of the National Assembly, right? So the speaker, put it this way, Justice Tolamo, his point is simple. What Mr. Tsinodi, that's why I praise him so much. What Mr. Tsinodi did was his job. He knew that the committee is not a fiefdom of Mr. Janji, but the committee of the National Assembly, which is the answer to the question you are asking. And hence, not Mr. Janji, Mr. Tsinodi, the speaker, took the initiative to say to the committee, as the Makulubas, the custodian of the process. He said, listen here, and he gives the most beautiful explanation. I'll come to that at paragraph 97 and 98 of his affidavit. He says, I know, as Justice Erasmus just said, I know that section 18, we would have had to go and do a section 18 application and whatever. But I didn't need that because, one, if the judge was wrongly appointed in the independent panel, then the whole thing is invalidated. But here's the most important part. He says, even if that judge thing is not, you'll find that at 1038, and in any event,
It's also summarized in Mr.
No, it's the speaker's affidavit. You'll find it in the speaker's affidavit, 1058.
It's in Mr. Judge's affidavit as well, on page 725. 725. It's where you were earlier, just under paragraph 19.
Yes. No.
Summarizes that.
Yes. No, I don't want
that comes from 97 and 98 of Senoli's affidavit.
Yes.
In the Concord.
Correct. No, I don't want that secondary. I want the verbatim words of Mr. In the speaker's affidavit. It's quoted verbatim. This is what our glorious Mr. Tsinori said. The reasons for my recommendations are the following. Let me start 197. Third, although the making of the present application for leave to appeal directly to this honorable court and of the conditional application to the full bench for leave to appeal to the SCA, which is another important thing that gets ignored, that they postulated, by the way, further litigation. The fact that that litigation happens to be now in the form of a rescission, not an application to the SCA, is neither here nor there. But anyway, for leave to appeal in the SCA will suspend the operation, see section 18. I've decided, not Mr. Janti, I've decided to recommend to the section 194 committee, again, not to Mr. Janti. That's why I'm saying when Mr. Tsinori was making the recommendation, he expected Mr. Janti to do the right thing and call a meeting of the committee. Which he didn't
so he says, I recommended
to Mr. Janti.
I directed Mr. Janti to cease any activities of the 194 committee. But I think we moved too far away from what I wanted to find out from him about the letters. But continue.
All right. So he says that he recommended as the speaker to the committee, which is how it should be done, right? The speaker, who is the custodian, as you correctly asked the question, recommends to the committee.
Yes.
All I'm saying to you, Justice Dolamu, is that surely, what that means is that Mr. Janti should have then called the meeting of the committee. That's what he says here. I recommended to the section 194 for meeting. All right.
But it's Tsinori.
Yes. Okay. So he was recommending to the committee, but he couldn't call a meeting of the committee himself. He called the chair so that he calls the committee. The committee could have said, we don't agree with that recommendation.
Exactly.
All right. So once you accept that, then you accept ipso facto that that was a decision not of Mr. Janti, but a decision of a committee.
The committee is established as a committee that has to do with the 194 process.
Ad hoc committee.
Right, ad hoc committee. And that committee is chaired by Mr. Janti.
Correct.
The speaker is not an ex officio member of that committee.
Correct.
It operates on its own in terms of the rules that they have agreed.
Correct.
So it can call its own meetings, isn't it?
But it did not. That's the point of it.
Now, what does 21 say?
21 says that, no, that's a different thing. That's 6 months later. We're jumping ahead. 21 talks about February 2022 now. Yeah. So that's a different matter altogether. I'm saying that in August of 2021, forget about 2022. In August of 2021, Mr. Janji took a decision, accepted a so-called recommendation, ultra vires, where that decision should have been taken by the committee, one way or the other. You and I have agreed, Justice Dolamo, that the committee could have said, we reject Mr. Tinodi's recommendation. Let's go the Section 18 route. But that decision was not taken to the by the committee one way or the other. It was taken by Mr. Janji. He says so in so many words, right? And then it says that the process which is currently underway in relation to Advocate Mkhwebane is suspended pending the outcome of the present applications for leave. If leave is granted, the decision appealable, this honorable court or the SCA, as the case may be. In other words, it could be a long suspension for years and years if it goes to the SCA, or it could be a short one. Because remember, what was postulating here is that it might go to the SCA and then go to the Constitutional Court. I'm quite sure by now it would not have been resolved. The Constitutional Court, of course, we know gave direct access. That's a story for another day. Nobody knew that at this stage. So, and he says this, Mr. Tinodi. The reasons for my recommendations are the following. It would be inimical to the proper legal or rational performance by the National Assembly of the duty of great importance imposed on it by Section 194, for it to proceed with the current process in the face of the order by a full bench of the High Court invalidating parts of the 129V, that's the one about the charge. If confirmed on appeal, will invalidate everything in that process from the date when Justice Kabinde was appointed to the independent panel. Let's just pause there. What Mr. Tinodi is saying correctly is that if the appeal on the judge issue is upheld, this will invalidate everything until that point. Again, I'm just guessing. Step 3 of the 17-step process, whatever it is. Okay? But here's the real issue. He says, moreover, even if the appeal against the order concerning 129V is ultimately successful, and here he was being prophetic, it was successful, the Section 194 committee is on the point of proceeding to hold proceedings, or rather to hold hearings. And here's the catch. He says, the proviso to Rule 129AD3 will preclude, that's the one that the Concord ultimately agreed with us on, will preclude any legal representative who Advocate Mkhwebane may appoint from participating in the committee. Right? The full bench order invalidating the proviso to 129AD3, if confirmed on appeal, which is what happened, will invalidate the proceedings in the committee should it proceed on the basis just mentioned when the time comes. Remember the words of Mkhwebane, when she says when that happens in the future. If I may, Justice Dolamo, just can I opportunistically just use that to finish the point I was making before lunch, because it's related. And that was 1988, Nhlanhla J's articulation. I stopped halfway. She said, the current process before the National Assembly to remove the public protector from the office has been suspended pending the outcome of this litigation, and the process has not yet reached the stage of the Section 194 inquiry before the Rule 129AA committee. As a result, the retrospectivity of the order of constitutional invalidity, will have no bearing on the lawfulness of the current process. And she used the word process, not proceedings. Advisedly, I'll come to the difference. And will not disrupt the steps already undertaken. Here's the big one. When the Section 194 inquiry formally proceeds, that in anybody's language means in the future. Okay? When the inquiry formally proceeds, the public protector will, in case anyone has any doubt that this is about the future, the public protector will be entitled to full legal representation in the committee proceedings. It's very obvious.
At what stage? At
Yes.
190.
Doesn't matter what, but it's in the future.
Yeah.
Let's agree. Yes. So when that happens, she will then be entitled. Now it goes back to the issue we were debating before lunch. You can't have it both ways. It's either you say Justice Mkhwebane was correct, and therefore the proceedings proper had not started.
Had not started.
Yes. In which case we know the implications of that. Or you say, no, we don't know what Justice Mkhwebane was talking about.
It's clear here.
Yeah, no, but
She says they
when-
have not started. When they start.
Absolutely, it's very clear.
So what stops Mr. Janji to do as he likes before the 194 process starts?
All right. I'm not going to. Honestly, I can't. What stops him, Justice Shivambu, is the fact
Because
that
he is not busy with the 194 process. He's calling his committee and says, gentlemen, have you seen the judgment of the Constitutional Court? Yes. What are we doing now? How do we take the process forward? He is not commencing with the inquiry.
well, he says he did on the 22nd. Let me explain. Actually, I'm not.
He said he resumed his work.
He
Resumed the
resumed his
committee's work.
Yes, it's work. But let me explain. I don't want to.
So let me ask you, let's make this practical. Let's say Mr. Leonti on the 21st of February 2022 had a WhatsApp group with all the members of this committee. And he said, in view of the judgment come out from the Constitutional Court, let's meet tomorrow.
Yeah.
What's wrong with that?
Yeah.
Everything is wrong with that. Let me explain to you. It is not Mr. Janji, okay? It was not Mr. Janji's business. Mr. Janji is not a party to the Constitutional Court process, all right? The person who is a party to the Constitutional Court process is the one who is abdicating her power, the Speaker. The Speaker, who now comes and washes his hands before this court wrongly, is the person upon whom the Constitution of this land, as the losing respondent, entrusts the task of implementing, I think is the right word, or executing the judgment. Okay? Let's agree with that. Is a simple proposition that is very plain. So Mr. Janji and even his committee, for that matter, for the purposes of this submission, have no business saying we are going to call each other rightly or wrongly. Now, I'm not going to go back to whether he himself had the right to do it. Let's say for the purpose of this he had. But it's not their business, him and the others, to be looking at the Constitutional Court judgment and then make a decision that we are going to continue. Because for two reasons. One is that this is a task of the Speaker, who is a party to the proceedings, which we all know. But secondly, the committee, as it were, cannot lift itself with its own bootstraps, and without even consulting the Speaker. Some say, we've read the judgment, we just saw the judgment somewhere on Safely, and we're now deciding to quote-unquote resume, which is wrong for a different reason. You can't do that, not in a constitutional democracy. The rule of law works like this. and this principle has been said in many cases. The most recent, I think, is about Ungan. In a constitutional democracy, a public functionary cannot exercise powers which are not specifically defined. So the power of and this is very crucial. You can't
continue. It's fine.
Okay, I continue. Thank you. It was explained, I think, but in the pharmaceutical case and federal, all the leading cases on the rule of law.
There's no doubt about it.
Yes.
There's no doubt about it.
Yes. So Mr. Janti or anybody for that matter, Justice Dolamu, cannot exercise a power that has not been specifically conferred to them. And our courts, the Constitutional Court has said this 100 times. The worst application of the rule of law that you can think of bastardization of the rule of law, is for a functionary to say, I will do this because I'm not prohibited from doing it. The Constitutional Court has warned 1,000 times against that. No, you must be empowered. It's the other way around. You must be conferred a particular power, and then you can exercise it. Where is the power of Mr. Janti to do the things that I've spoken about?
Do I understand you to say the committee, Mr. Janti's committee, is illegal? It shouldn't exist. I'm not sure. I want to find out whether I understand your argument. It is a legal committee established by the Speaker.
It's on 16 March 2021.
Mm-hmm.
Yes.
So what stops it from functioning?
The law. The law says that even if the committee is functioning, it can only do those things that it is empowered to do. One of those things, Justice Gallo, is not to make a decision that it's a self-serving decision that it will resume the functions. That decision belongs to the person who was stopped by the highest court in this land, that is the Speaker, from proceeding without full legal representation. And this is important because, let's say for argument's sake, the Speaker said, look, I want to get proper legal advice on the meaning of the Clarified judgment. Okay? Postulate, work with me here. Suppose the Speaker said that, gee, there's this judgment. I'm not a lawyer. I don't know what is the meaning of full legal representation. Does it mean it goes back to the panel to say, I'm just to the panel decision? Does it mean at the next meeting there must be a lawyer? Or what? Okay, because Justice Mkhwebane has said, when the Section 192 formally proceeds, the public protector will be entitled to full legal representation. So let's assume then, on their spurious interpretation, they take that the fact that they are saying that the formal proceedings started in 2021. Okay, let's assume that for a minute. Then that would mean, Justice Dolamo, that lawyer X would have said to them, okay, the implications of the Constitutional Court judgment are that at its next sitting, the committee must have a lawyer of the public protector. All right? No. And please work with me on this example. While the speaker, in my notional example, is awaiting the legal advice, our Mr. Janki wakes up, calls the meeting, analyzes the judgment, decides it's all systems go. He doesn't. I'm sorry.
Continue.
No, I'm sorry, just.
Because I was going to point out that the judgment of the Constitutional Court says that process has not yet reached the stage of Section 194 required.
Yes.
And then it specifically said, when that stage is reached, she can get legal representation.
Yes.
Then.
But who knows?
Janji doesn't say, I'm now in the 194 process, which needs the participation of the public protector.
No, that's not so. Janji says.
What is Janji saying?
Okay,
he says we did our work.
No,
He doesn't say we deliberated on the merits of the charges against the public prosecutor in her absence.
726.
They could have been making photostat copies of the documents they're going to be using.
No,
And you say they can't do that.
No, that's not what I'm saying. I'm going back to the point I've been making so many times that they can't have it both ways.
I agree with you. I agree with you.
I'm saying, Janji, you say, Justice Tolamo, Janji says, he doesn't say. Janji says exactly that. Actually, he says West. Janji says, no, before that. Janji says,
and this debate I'm having with you, Mr. Kofi, is on the assumption, and that is what you agreed in the morning, that
the process has not started.
Has not started.
Yes. No. But okay. But I accept that, Justice Tolamo. What I'm saying is that you just said now that's not what Janji is saying. I'm showing you that Janji says something worse than what you're saying is not saying. His case here, in this mountain of paper, is that the process started in July 2021 already. Okay, I'm busy showing you that that theory is wrong. Not as an assumption, as a fact.
That's his version.
Yeah, that's his version.
Yes.
Now I'm saying, therefore, that
this court has to determine whether indeed it started back then in line with what he says and in line with what the Constitutional Court has decided.
Correct.
The Constitutional Court has said when that stage starts, then this is where legal representation is necessary.
Okay, let me make it very simple. I don't care, and I'm not saying that loosely. Maybe let me put it better. It does not matter for the public protector if you find that the suspension is illegal because the process has not started, which we forcefully argue, or you say it has not started because there was no terms of reference. I'm just choosing any other indicator, okay? Which is also simple, Justice Tolamo. If you go to paragraph 229 of the SARFU case, the Constitutional Court...
The one you quoted in your head?
Yes, the same one, SARFU 1. If you go to paragraph 229 of that case, it explains the purpose of terms of reference, and I'm sure, Justice Tolamo, you're not going to
Here we go.
Are we back?
Yeah.
Thank you. I was simply saying, one doesn't need an LLB for this. Remember, there are many reasons why we show that it hasn't started. You and I have discussed the first one, which is in cancer judgment. But there's a plethora of other reasons. One of them is this issue of the terms of reference. Mr. Janchi, again, tells you in open, in flagrant, in front of everyone. Sorry.
Judge. It's not working back here.
Sorry.
Go back. No.
Okay.
Yes. We still off. Okay.
Just to get the
Connections
working.
Yes,
This
please.
one is connected, and it's connected on that Wi-Fi. This was
We need the other one.
so, just gonna get the IT people are here somewhere around.
Somewhere, lacking somewhere. Otherwise, we can go on the basis of my voice, if they can see me.
We'll adjourn for about
5 minutes.
If not, we'll go on the voice.
Let's call this one.
Ungathithi sokulo.
Yeah, I don't
Ndinenza i-sacrifice ndizohlala apha till 5
Eh?
abakwazi ucima.